Good morning, everyone, and welcome once again to Uncivil Law. I hope you're having a great day. We tune in once again for Karen Reed, Trial 2.0, as the state continues to make its case. Yesterday, we heard from a woman wearing an onion hat who wanted to tell us about how when a server brings you a pepperoni pizza, sometimes people are sad. That was interesting testimony. And we continue again with more testimony relating to the investigation. Presumably, we will continue to hear from police investigators. And if I'm right about the timing of the thing, then probably Proctor gets called on Friday afternoon or Monday morning seems like the most logical time frame for Proctor to be called. And then we continue from there with things as we do. But of course, we will see how it all plays out as the case continues. We are on day 12 of the case, as we are. And we will see how things progress. Yep. Great. How are y'all doing? I had improv last night. First time in like 3 or 4 weeks, something like that I had improv. Learning now long form improv. Yesterday we did what they're calling a slacker, which is where you have two-person scenes and you just do a series of tag outs. Wherein the person who remains, so you have two people playing two characters, someone tags someone else out. The person who stays on scene is the same character. The person who comes onto the scene is a new character interacting with the old character, and you just keep switching it. So, so you have A and B, A gets replaced, B remains the same character. So now you have C and B, then B gets replaced, C is the same character, C and D, and so forth and so on. It's a way of doing character. It's a way of doing character development and stuff like that. So very interesting. And then next week, apparently, we're doing the round, which is wherein you have the same character, and then you do a montage with the same character. So kind of you do the same thing in sort of developing the characters, but in this frame, when the actor comes on screen or on stage, they're always playing the same role. So in the first version, when you come on stream or come on the stage, you're not playing the same role every time. But in the round, you are playing the same role every time, and then it becomes an interaction with how the characters interact with each other. So that's fun. So character development versus character interaction, I guess. And then, of course, eventually we're going to get into the Herald, which I've done before in DC, which is one of the more infamous long-form formats. And that is requires a lot of memory and requires a lot of time to make that work. So in the Herald, basically you have like an A, B, C scene, and then you have A2, B2, C2. So they develop, so you like do A, B, and C. So you have like A, B, and like C combines A and B. Then you do A2, B2. So you like redo A with like new development, B with new development, and then C. And then like, I forget where it goes from there. It's been a while since I've done Herald, but that's okay. We will learn it again. The improv class is now 10 people. So it's a larger improv class, which is better for dynamics, I think. So all that good stuff. I've been doing improv for a couple years. I did it when I was in DC, and I've done it So I've just done it. It was initially just a way to. The reason I got initially interested in improv is because I've been doing public speaking for a long time, Toastmasters for a long time, and I was just looking for a way to continue developing my skill set. And in Toastmasters, you have impromptu speaking. So they give you a topic that you've never heard before, and then you have to like talk about it for 60 seconds to 2 minutes. And so it's like you already have a little bit of that skill set anyway from Toastmasters. And then it's like, well, how do I continue to develop this? And improv seemed like a reasonable way of continuing to extend that. And so then I got into improv, and that's fun. Yeah, the class size is important, exactly. Like our old class, unfortunately, kind of got down to like 4 people, which is too small. 10 is maybe too big, but 4 is too small. You need enough people to have enough interactions. So you need enough people to have enough dynamics to make things interesting, and also give each actor a break. Yeah, with 4 also you can't observe enough. Yeah, that's also true. You can't also like learn from what other people are doing. Yeah. But I now have a completely new group of people because my old class is dissolved. So I'm joining a pre-existing group, and I'm the new guy now in that group. And so I don't know any of these people. And so that makes things challenging for both of us, right? Because it makes it challenging for me because they don't know me yet. And it makes me challenging for me because I don't know any of these people, so I don't know how to interact with them yet. So we were doing the slacker format yesterday, and I definitely didn't feel like I was at my best for any number of reasons. Also, I'd forgotten that improv was even happening, so I showed up an hour late into a 2-hour class, which wasn't ideal, but what can you do? Pressing on. Yeah, there is an instructor, and I've worked with the instructor before, so I've got that going on for me. So, yeah. I'm still trying to wake up, by the way, so it's going to take a hot minute. Spinny fan continues to spin for justice. We stand Spinny fan. Yeah. I'll wake up in a second, guys. It's just, it was a long day. Yesterday I didn't get much sleep the night before. I got decent sleep last night, but I'm just trying to wake up still. Oh yes, ads, right. I have to change that. Thank you. Yep. Yep. Okay, change the ads, customization, change to subscriber only, put on slow-mo to 15 seconds. Save those settings. Great. Excellent. No problem. Let's see what's going on. Texas is standard time. At least this part of Texas it is, yes. There's a little bit of Texas on the very west that is not, but yes, for the most part, Texas is central time. It is 7:58 in the morning. Yeah, a debrief with Runkle and EDB would be fun. Sure, of course it would be fun. It'd be interesting to see how we differ in our perceptions about things. Do we get any food-based explanations? I don't know about that. Thanks for the laugh. I need at least one laugh to get me going this morning. Hmm. Make sure to hit the like button, by the way, and make sure to hit the retweet button on the pinned link. It's appreciated. Yeah, let's tell jokes. Jokes are good. How do I think Brendan will handle Proctor? Throw him under the bus? I think you got to throw him under the bus. I think is the way to do it. That's the thought that comes to my mind. If I were Brennan, my thought here is I call Proctor Friday afternoon, get him started, or Monday morning. Either one is equal. It's sort of even money between the two. Um, I don't know which is better between Friday afternoon and Monday morning, but Friday afternoon I call Proctor. Let's say. So I got 4 hours with him on the stand. So I spent 4 hours with him on the stand, just kind of doing the good parts of his investigation. Just trying to walk through like, just trying to, talk about, things in the make to make not necessarily make him look good, but not to make him overtly look bad. To make him look good would be nice, but not necessarily required. So let's say neutral, right? Make him look neutral. Good would be nice, but we do what we can. So I spent Friday afternoon with him. If I'm Brennan, I spent Friday afternoon with him neutral, leaning towards good. Then like first thing Monday morning would be my impulse. Like first thing Monday morning, like question one out of the gate Monday morning, I beat him to death. I beat him to death in every possible way I can dream of. I just absolutely beat him to death and throw him under the bus in every possible way that I can dream of. I ask him every question that I can think the defense might want to ask him. I ask it obviously a little bit differently than the defense would. That's why I have control. So I ask it differently, but I get the information out. So I spend, let's say 4 hours of Monday, beating him to death. And then perhaps spend, some time Monday trying to rehabilitate him a little bit. And so then the defense takes over either sometime on Monday with Cross. They beat him to death for Monday and then into Tuesday. And then hopefully, I can sort of do some rehabilitation Tuesday afternoon, get him off the stand, completely by the end of the day Tuesday. And then I have Wednesday, Thursday, and Friday to like try to make the jury forget about everything. That's sort of my thought that comes into my head about how to do this tactically. So, yeah. I mean, because I don't know that there's any alternative. It's the least bad option. That's the problem, right? So what do you do here? It's like, well, can I not call Proctor? Is my first thought as the Commonwealth. Can I not call him? It's like, well, if I don't call him, surely the defense is going to call him. And then, of course, they control him and they just beat him to death. And that's not ideal, right? So I don't want to do that. I don't want them to call him because they're going to call him and, beat him to death in a less favorable way. You see, if I'm controlling it, I can beat him to death more kindly. The beating is a little bit more friendly. So I can't do that because I think the defense would call him, and that doesn't work for me. All right, so not calling him isn't really an option. All right, so what's my next preferred alternative as a lawyer? All right, my next preferred alternative is, all right, is there any way for me to basically make the bad parts disappear? And well, no, not really. I can't really make the bad parts disappear. I mean, I could try, but no. Not really. Can I make can I make the fact that he was dishonorably discharged disappear? Can I make that not something that they can bring up? It's not really. Even if I won that motion in limine, I won't really win it. If somehow I got the judge to agree, you can't mention the fact that he was, dishonorably discharged, it won't really matter because they'll just basically ask every question but that anyway. So it's it doesn't really matter. So it's well, I can't really do that because it wouldn't work even if I could. So it's okay, so I can't not call him. I can't suppress it. So what's the only other option, or what is the next option? Well, the next option is, then I bring it out, right? I bring it out. Which also has the benefit of, it has multiple benefits. First of all, it shows the jury that I'm not trying to hide anything, so it builds credibility for the jury. That's nice. Second of all, I, draw the sting so that the defense doesn't have anywhere to go.
Hear ye. All persons having anything to do before the Honorable Beverly Canoni, Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
Sidebar?
Good morning, counsel. Good morning, Ms. Reed.
Good morning, jurors. This is great. This may be the earliest we've got started, so I appreciate everybody being ready to go right away. I do have to ask you those questions. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes and nodded affirmatively. Were you also able to follow my instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes and nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. Everyone said no or shook their heads.
Thank you. Mr. Brennan, your next witness, please.
No sidebar? What? What court is this? What court is, we're calling a witness? What do you mean we're calling a witness? Since when do we call witnesses? Okay.
Thank you, Your Honor. Commonwealth calls Yuri Bukhenik.
All right. Okay. All right. We're calling a witness. I don't understand. I'm confused. I don't get it. By the way, Bukhenik himself was sanctioned. He forfeited 5 vacation days. I know, but still, he forfeited 5 vacation days for his failure to properly supervise relating to this bullshit. So that will also be brought up. I'm sure that will be fun.
You can put it. Please, the clerk.
You solemnly swear to be able to speak to the court and jury in the case now and hearing to the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. You take this.
Good morning.
Good morning, Your Honor. Good morning, ladies and gentlemen.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Yuri Bukhenik. My last name is spelled Bukhenik.
Mr. Bukhenik, where do you work?
I work for the Massachusetts State Police.
What is your role with the Massachusetts State Police?
I'm currently assigned as a sergeant with the Norfolk District Attorney's Office in the Homicide Section.
I want you to take us back before you became a state police trooper with the Norfolk County District Attorney's Office. Where were you born?
I was born in Lviv, Ukraine.
Did you immigrate?
Yes.
How old were you when you immigrated?
I was 9 years old when my family moved to the Boston.
I feel like there's a joke to be had that he was born in Ukraine. I'm not sure what the joke is, but there's a joke to be had in here. Something in Soviet Ukraine police. I don't know. There's a joke to be had in there somewhere. You guys can help me write. It's early in the morning. I need help with my comedy skills. It's not quite happening yet. I'm not that awake yet.
Boston area.
Did you attend public schools?
Yes.
Through high school?
Yes.
Tell us what you did after high school.
After high school, I enlisted in the United States Marine Corps.
Why'd you enlist in the Marine Corps?
It was right after 9/11, and my friends and I.
It's basic background. It's basic background. It's fine.
Go ahead.
My friends and I decided to serve in the nation's armed forces.
Did you serve in the Marine Corps?
I did.
Did you go through training?
That was a cheap objection by the defense. I'm sorry. I mean, I know that you don't die, but it's basic background. I'm sorry. The man served in the Marine Corps. It's a basic background question. You just kind of have to eat that a little bit. I mean, that was a cheap objection. Come on.
I did.
Did you learn any skills?
My specialty was military police, and I attended military police school at Fort Leonard Wood, Missouri.
Through your military service, did you receive top secret clearances?
Yes, my first duty station was with Marine One Presidential Helicopter Squadron. The duty station requires a top secret Yankee White.
Ooh,
SCI
Yankee
clearance.
White, Yankee
And,
White clearance.
As a result, I
Exciting.
obtained that clearance and held it throughout my career.
Did you engage in any special assignments?
The Presidential Helicopter Squadron is a special assignment. We provide security for the presidential helicopters and presidential assets. With that clearance, we read into a SCI program, which is a need-to-know basis type situation.
How long were you in the military for?
4 years.
When you discharged from the Marines? What year?
2006.
Honorably discharged?
Yes.
After you were honorably discharged from the
Honorably discharged is more than we can say for some of the cops involved in this case. Am I right? Yeah.
Marines, what did you do next?
I had a passion for law enforcement, and I wanted to serve my community here in Massachusetts. So I left California and came home and applied for various police departments, ultimately getting a job with the VA Hospital Police here in the Boston region.
When did you transition from the VA to the Massachusetts State Police? What year?
I actually transitioned to the Attleboro Police Department. I worked there as a patrol officer, SWAT team member, and then in 2011, I transitioned from Attleboro to Massachusetts State Police.
When did you join the homicide unit?
It was May of 2015.
And have you been in that position since?
I have.
And you're now a sergeant in that?
I am.
Yeah. This is all fine. This is all
I want to
routine,
ask you
standard
about the
background.
structure of the homicide unit
Yeah, that was just a cheap objection by the defense. That was perfectly routine, ordinary, standard background stuff. He didn't linger or dwell. It's just that those are the facts, okay? It is what it is. It was a cheap objection. Does it make him look great and look like a hero? Yeah, but that's just what it is. Yeah, you kind of have to eat that. That was a cheap objection by defense. Bad pull, bad defense. That was a mistake. Don't do that.
For the state police. How many different troopers work in the homicide unit at Norfolk County DA's office?
We have a range from 2 to 6 troopers working in the homicide section over the years that I've been there. Currently, we have 6 homicide detective troopers in the section.
What type of cases does your unit investigate?
Our unit investigates primarily unattended deaths. Unattended deaths are those that are not attended by a physician. A variety of deaths, including natural deaths of old age, medical conditions, accidental industrial accidents, obviously homicides, overdoses. We have suicides as well. And those vary in age on the victims that pass, whether they're stillborn infant deaths, children that pass away of SIDS, or unfortunately teenage suicides.
Have you been to a number of scenes, a number of cases?
Yes, I have.
Do you handle more than one case at a time?
Yes, we do.
When a case, an unintended death, is notified to your office, is that routine or is it by statute?
The notification comes in due to the statute requirement. In Massachusetts, under Mass General Law, Chapter 38, Section 4, the authority is given to the district attorney in each county to investigate those deaths. They appoint designees, and within Norfolk County, those designees are law enforcement agents from the Massachusetts State Police. So in our county, the Massachusetts State Police, with the district attorney's authority, investigate all unattended deaths.
You mentioned that it's called the homicide unit. Are many of the deaths that you investigate not homicides?
Primarily, the death investigations are not homicides.
When you walk into a call, do you have a preconceived notion whether it's a homicide or not a homicide?
When we walk into a call, we take in all the evidence, so we do not know exactly what we're going to have as a finding. We follow the evidence, we follow the information that we're provided, that we learn throughout the investigation. At times, it's obvious that it was a homicide when the local agency that's reporting the death says that there was a shooting reported and there's a deceased person at the scene. So yes, we will know that it's most likely a homicide, but we don't make a preconceived notion or determination before we get there.
You said there are a number of cases that go through your office. Do you work investigations by yourself?
Never, no.
Are investigations assigned to the group as a whole, or is a particular trooper in the unit?
We have case officers, and the assignment of the responsibility when you will most likely be a case officer is scheduled a month or so in advance. So each trooper has a responsibility of a 24-hour period that they are on call. They respond to the scenes, whether it be a train strike versus pedestrian, or a vehicle, or a suicide by hanging. They respond, and then if they need assistance or they think that there's something more, additional resources are called out, like crime scene services, which helps us document scenes, etc.
Have you ever been assigned a homicide or a homicide investigation?
Yes.
In the cases where you're assigned, do you investigate the case alone?
Never. It's always a team effort. Every case requires a team effort. Just the amount of work that goes into collecting evidence, interviewing witnesses, interviewing involved parties, interviewing the suspect. All those tasks that are required in collecting surveillance footage require manpower and time and resources. And so every investigation, although it has a case officer, it requires a team effort of individuals to work together in concert to accomplish a successful investigation.
Are you often working on more than one investigation at the same time?
Yes, we are.
If you were the case officer, would you have other resources you would use to help with the investigation, other units in the Massachusetts State Police or local police?
Yes, typically we partner up with the local police detectives, and when we're conducting interviews, it's a state trooper and a local detective that are conducting those interviews or collecting surveillance footage and so forth. And there's a reason behind that. The reason why we pair up is not just the manpower, it's also that we work in a dangerous line of work, and people could lose their life, people could get injured, or unfortunately people could get fired or retire and no longer be available to testify, provide their testimony, or be a resource in the future.
Is it a common practice that when there's an investigation, more than one trooper will appear at many events?
It is very common and preferred. Unfortunately, in the real world, it's not always possible. A trooper can be responding to a scene and just to simply grab something from another trooper and could be approached and a small brief interview could happen, or if a trooper's at a home talking to a witness and others show up and willing to provide information, he has to conduct that interview by himself because of the resources aren't available for him.
Let's talk about the assignment of this case. You said that there's case assignments, a schedule that is made in advance.
Yes, sir.
On the day or the morning of January 29, 2022, do you know who was assigned to take calls for new cases?
Yes, before 7 a.m. on the 29th, it was Michael Proctor that was assigned to be on call.
Is there a supervisor assigned as well, in addition to a trooper that's not?
Yeah, so he's the supervisor of Proctor. So this makes sense in sort of the flow of the trial that we call this guy first. This guy himself was disciplined for Proctor. We call this guy first, which then the defense will raise the fact that he was disciplined relating to Proctor, which sort of gets that sort of initial idea in front of the jury, which isn't bad. Then you call Proctor. But I'm not sure it makes sense in terms of the calendar, because I don't think you want to call Proctor right after this guy, because you don't want the defense again to cross before the weekend, because they're going to make the cross painful, and you don't want the jury thinking about that all weekend. So, but yeah, it seems like the way the story is being developed, we're looking at calling Proctor pretty soon, I would imagine.
In a superior position?
Yes,
Yeah.
Every day there's a supervisor assigned in addition to the on-call trooper. There's a supervisor that's also available for any reason at any time to respond, assist that trooper if there's any questions or issues that come up.
Was there a supervisor assigned that morning?
Yes, there was.
And who was that?
It was myself.
When did you first hear or learn anything about this call or this case?
In a unique fashion, this call actually came from the Troop H headquarters, which is the field services portion of the state police, the uniform patrols that service the Metro Boston area. The headquarters duty office contacted me, I think by mistake, misdialing the number because our names and numbers were listed one above the other. So the call actually came into me. I took the call and advised them that I would call the on-call trooper for that day, and they would contact Canton PD and take the appropriate steps.
About what time did you receive a call that morning?
Approximately 6:44 in the morning.
After receiving the call around 6:44 that morning, did you contact anybody to assign a case manager, or did you get involved personally?
I called Michael Proctor and told him to reach out to Canton and follow up on the report of a male in the snowbank.
And this is around 6:44 a.m.?
Yes, sir.
What did you do next?
I waited for a call back from Michael Proctor, and he reported the details of, yes, there was a male found in the snowbank in Canton, and that they were requesting our assistance as he had sustained injury and was unresponsive and had been transported to Good Samaritan Hospital.
What was the plan at this point?
At this point, where I learned that he had sustained injury and there was a heavy blizzard in the area, I decided myself to get dressed, shovel out, and respond to Canton.
Were you required to get involved and go to Canton that morning?
At this point in time, I was not, but I thought that it would be prudent on me to, at the very least, shovel out, because another call could have come in and I would have had to respond to that, and the driver would have been shoveled.
Were you in touch with Mr. Proctor?
I was.
Did you have any plan to meet him?
Yes.
When and where?
We decided to meet at the Canton Police Department.
Okay. And about what time were you going to leave your home, or did you leave your home?
I left my home probably around 8:50, and I know I arrived to the Canton Police Department approximately 9:15 in the morning.
Did you know the address where the person was found in the snow?
At that time, I learned the address once we got to the police department, but it had no significance for me. I did not know where it was.
Why did you plan to go to the Canton Police Department instead of going to the scene first?
The Canton Police Department, fire department personnel, and paramedics had already cleared the location. So we, again, given the conditions, we were in a controlled environment inside a police station to exchange information, collect any evidence if it was available, and the police department safety and security of that would have been the best location for it.
You mentioned that you arrived at the Canton Police Department around 9:15 a.m.
Yes, sir.
Was Mr. Proctor there when you arrived?
Mr. Proctor was there walking in with me.
Mr. Proctor, indeed. Mr. Proctor. Yeah. Why Mr. Proctor? Hey, well, yeah, let's ask that question.
When you went in with Mr. Proctor that morning, who did you meet?
We went in, we met with multiple Canton police personnel, one of which being Sergeant Good. He was one of the first responders to the initial scene.
Did you receive any items from Sergeant Good or any of the police officers while you were there?
Yes, we didn't receive it, but we were shown a broken cocktail glass, bottom of a broken cocktail glass. We were provided Mr. John O'Keefe's cell phone, and I was also shown a brown paper bag with 6 plastic Solo cups in it, containing what was reported to be blood in the snow.
When you were shown these items and had a discussion with the Canton Police Department, were any decisions made about the future of the investigation? You had shared with us earlier that typically the state police pair up with local detectives. Did you do that morning?
That morning, we did not. We had learned that there was a loose familial connection through town channels with the address and possibility of a Canton police officer or detective. So Canton police, out of overwhelming precaution of impropriety, not that there was one, decided to step away from any interview investigation assistance with us.
Has that happened in your career before?
Yes, it has, yes.
Since there would be no local detective, did that change your role at this point in the case, your involvement?
It did not change my involvement, but it did bring up a concern of manpower. We are obviously limited by staff. The weather conditions also further exacerbated that issue. So transportation was an issue, timing's always an issue, and you can never have enough manpower.
Did your role become more prominent, given there was no local detective involved?
I would have to pick up the slack. I'm a team player. I always want to assist in any which way I can to make others' life easier.
And you were Mr. Proctor's supervisor?
I was.
After you received the broken glass, the cell phone, and you saw the plastic cups with the blood in them, where did the evidence next lead you?
Based on the information we had learned and the evidence, we decided that we needed to speak to the individuals who were last in contact and present at the scene when Mr. O'Keefe was found.
Did you have any specific other information that you were following at that point?
Yes, we had statements made by the defendant that she was questioning whether she had hit him, and to that extent.
Had you focused in on a target at this point or reached any conclusions about your investigation?
No, we were still in the information and fact-finding portion of the investigation. We are not ruling out people as much as we're not ruling people in as much as we're ruling people out. So we need to get as much information as possible that is in physical form, statement form, and circumstantial factors as well.
So where did the evidence take you next?
Following 3 interviews conducted in Canton with witnesses, we proceeded to the Good Samaritan Hospital because, based on the information I learned, I needed to put eyes on Mr. O'Keefe and his injuries. I needed to see what exactly the witnesses were describing.
Do you remember who you spoke with that morning before you decided that you wanted to go to the hospital to see Mr. O'Keefe?
Yes, we interviewed Miss Jen McCabe, Mr. Matt McCabe, and Mr. Brian Albert at the McCabe residence.
How long, or about what time did you get to see Mr. O'Keefe?
We got to see Mr. O'Keefe, I would approximate probably like 12:30, maybe 1 o'clock-ish.
Why did you want to see him specifically?
I wanted to see the injuries for myself, the location of the injuries, the types of injuries, the extent of the injuries, and overall condition that his body was in would be very telling. The mechanism of injury, how it might have taken place, and also the correlation of any evidence at the scene with those injuries.
Now, you don't have any medical degrees, do you?
I do not, no.
How about biomechanical engineering?
No.
Do you have life and job experience in these situations?
Yes, 20 plus years of law enforcement investigating car crashes, pedestrian crashes, and 10 years in homicide.
Your role is not to make a diagnosis, is it?
No, it's not.
Is this information and your interpretation based on your experience important in guiding what you're going to do in the investigation?
Yes, it is very.
Do you ultimately get to Good Samaritan Hospital?
Yes, we do.
Okay, take us through what happens when you get there.
When we got to Good Samaritan Hospital, the driving conditions were treacherous. It took us 45 minutes from Canton Center, basically, to Good Sam, which should be a 15, 20-minute drive. At one point, I had to get off the highway because I couldn't tell if I was on the roadway, if I was off the roadway. So the guidance of trees on the side of the road through the town streets actually helped us guide the path to Good Samaritan. Once we arrived, we walked to the emergency department where Mr. O'Keefe was initially treated and where he remained. Upon arrival, we spoke with medical personnel who advised us that the defendant had at that point been discharged from the hospital, and that Mr. O'Keefe was still in the emergency room and available for us to view.
At that point, you said the defendant had been discharged. She was not the defendant at that point.
No, she was not, no.
Did you have a chance to enter a room or actually see Mr. O'Keefe?
Yes, I did.
Had he passed at that time?
Yes, he has.
When you walk in the room, what do you see?
When I walked into the room, I saw a medical bed in front of me. Mr. O'Keefe was covered with a sheet, as is typical with any victim that had passed. There was a pile of clothing to the left, at his feet to the left of the bed. I observed several injuries on him once I lifted the sheet, and those were documented with photographs by Crime Scene Services, a member of the state police, who also met us at the hospital for that purpose.
So there were other members of the team that were there to photograph
Yes,
Mr. O'Keefe and some of the injuries?
yes.
How many people were in the room with you and Mr. Proctor when you were observing and viewing Mr. O'Keefe?
There was a total of 3 of us, myself, Mr. Proctor, the Crime Scene Services individual. There was medical staff coming in, nurses asking us if there was anything that we needed to assist us with. But from law enforcement, it was 3 of us there.
Now, I don't want you to try to give us a diagnosis or provide us an opinion of the cause of any injuries, but rather I want you to share with us, as you're observing Mr. O'Keefe in that hospital room, what are you seeing and what is standing out to you?
I saw pooling of blood underneath his head. There was seepage of blood into the sheets. There was also swelling, discoloration, a large amount of blood pooling underneath his eyelids. There was no abrasions or injuries that I observed to that region. So to me, through my training experience, I took that as subdural.
Not to any medical observations, but just you as law enforcement.
Yes, Your Honor.
I'd ask you not to give your personal interpretations of what you saw. Rather, I want you to share with the jury what you saw through your view.
There was also a tiny cut, laceration to the eyelid area.
You're pointing to your right eye. Could you be
Yes.
specific, please?
Also on the left nostril, there was a very small laceration there. Both were not actively bleeding. There were a series of cuts and bruises to the right arm, which extended from approximately mid forearm up to the mid tricep area of Mr. O'Keefe, and they were concentrated on the exterior of the arm. There was no other injury or marks on the interior or inside of the arm. There was also a bruise on that same arm on the back of the hand. It was light in color. It wasn't a profound discoloration as the eyes appeared to me. There were also injuries to abrasion or cuts, scrapes to the knee, I believe.
Which knee?
The right knee. I apologize.
You had first described swelling in the right eye, and then you had just said the eyes. Could you be specific? Was the swelling in one or both eyes when you saw Mr. O'Keefe?
When I saw Mr. O'Keefe, the swelling was in both eyes. It might not have been exactly symmetrical, but there was swelling, discoloration in both eyelids of Mr. O'Keefe. There was also blood pooling in the cavity of the eyeball, both sides of the eyeballs.
Do you know about what time it was that you visited Mr. O'Keefe and made these observations?
It was sometime between 12:30, 1 o'clock, and 2 o'clock, I would assume.
You mentioned that there was pooling on the back of Mr. O'Keefe's head. Did you look for any injury?
Yes, we looked for injury. All I could tell, there was bleeding happening. I could not tell exactly what the extent of the injury was, not being a medical professional.
You mentioned there were a pile of clothes in the floor. Is that uncommon?
No, it's not uncommon at all.
Did you have any opportunity, or did you decide to look at those clothes?
Yes, what happens, the reason those clothes are on the floor is that for medical therapy, for medical treatment, the victim has their clothing removed for access to the body. There's obviously all sorts of equipment and medical procedure that's done. So that clothes is discarded. We knew that it was Mr. O'Keefe's clothing. We knew that it would be important to aid us in the investigation. So that clothing was picked up, identified item by item, and bagged. It was in a soaking wet state with moisture and other debris on it.
When you are looking at Mr. O'Keefe, do you have to touch him and move him?
Yes, during our investigations, we're not simply looking at photographs. We are there in the scene. We are smelling it. We are touching it. We are, unfortunately, with certain pungent scenes, we were tasting it. That's the reality of us breathing in the scene when we're living it through the investigation.
Do you wear any type of protection?
Absolutely. We wear gloves. At times, we wear other PPE, personal protective equipment.
When you looked at Mr. O'Keefe's clothes, you said that you bagged them. Did anything stand out in particular about his set of clothing?
In particular, we were missing a sneaker of his. That was very significant to me. It caused me to have Michael Proctor contact the paramedics that transported Mr. O'Keefe to the hospital and confirm with them, conduct a secondary check, that that sneaker was not left behind in the ambulance.
Why was the missing sneaker significant to you at that point?
At that point, our theory had evolved to a vehicle strike based on the injuries, and I was suspecting that he was hit out of his shoes.
Is there a phrase that's common in these type of situations?
Yes.
What's that?
Knocked out of your shoes?
Did you know where the other sneaker was?
I did not, no. But I suspected, since it was missing, and once the reports came in that the paramedics, EMT personnel did not find the other sneaker, that it would be somewhere where Mr. O'Keefe was found or where he was initially struck by a vehicle.
Did you and Mr. Proctor have an opportunity around that time, 12:30, 1 o'clock, to go back to that address to look for the sneaker?
We did not know.
Why not?
Again, during the critical early hours of an investigation, timing is essential. We have to make sure we get to any and every location that could possibly have evidence and prevent that evidence from being destroyed, altered, or concealed. So we are prioritizing missions. And with the resources available at that time, I conferenced with my boss and advised him of the current status of the information that we had. And he stated that he would go out and marshal up resources to conduct a search.
Is this an example of the team approach of the state police at the homicide unit?
Sustained.
After having this information, making these observations of Mr. O'Keefe yourself and bagging the clothes, where did the evidence lead you next?
At this point, once we viewed the clothing and Mr. O'Keefe, we had to go talk to the last person that saw him, and that would have been, at the time, his girl,
Who'd you go see?
the defendant, Your Honor.
The prior question wasn't answered, so prior questions.
Did you know where Miss Reed was at that point?
Yes, we had learned that she traveled to her parents' home in Dighton.
Did you learn about any, or did you have any interest in any physical evidence at that point?
Yes, with the missing shoe, her stating that, did I hit him, and along that line of statements, I was interested in the vehicle that she was operating that night.
How far was Dighton from where you were at Good Samaritan Hospital?
Typically, I would say it's probably a 35, 45-minute drive. With the driving conditions, it took us all of an hour, 15 minutes.
Who was driving?
I was driving.
Were you in a issued vehicle, or were you in a personal vehicle?
No, I had to drive my personal pickup truck due to the weather. My cruiser would have never made the unplowed streets of the area.
Was Mr. Proctor with you?
He was.
Were you by his side the entire time?
Mr. Proctor and I were together the entire day.
You decided to go or drive towards Dighton. Did you ultimately make it to Dighton?
Yes, we did.
Do you know what time you arrived in Dighton approximately?
Approximately 3 p.m.
On your way down to Dighton, did you learn any further information beyond what you had known when you had left Mr. O'Keefe at Good Samaritan?
Yes, at one point, Michael Proctor took a call from Jen McCabe, and she further elaborated and provided information stating that she remembered.
Sustained.
After receiving that information, is there something specifically you wanted to look at when you got to Dighton?
Yes, we wanted to look at the rear right tail light. Based on the information provided, it was allegedly to
Let me
be.
stop you there. I just wanted to know what you wanted to look at.
Yes, sir.
I don't want to relate conversations of somebody who's not here. And so you had an interest in looking at the right rear tail light?
Yes,
Do you know what type of vehicle you were looking for?
we were looking for a large black Lexus SUV.
When you made your way down to Dighton, you said you finally arrived. How did you know you were at the right address?
The defendant provided her parents' address to us.
Before you got to Dighton, after learning of new information and the information you already had, did you make any arrangements?
Yes.
Tell the jury what you did on the way down to Dighton.
On the way down, we contacted Dighton Police Department and gave them a heads up that we would be coming down for an investigation, and we were looking to most likely seize a vehicle. And we were requesting their assistance in contacting a local tow truck company that they were contracted with, and/or also to assist us at the scene, being a uniformed presence.
When you pulled up to the address, did you make any immediate observations while you were still inside your truck?
Yes, the road was not well plowed. There was only enough clearance for one vehicle. So it was difficult to find a place to park, and maneuverability was also challenging.
Did you make any observations of the home or the driveway before you got out of your truck?
Yes, the home is to the left of the driveway. The driveway was not plowed either. There was a large black Lexus SUV parked in the driveway.
Was the front of the SUV facing you or the back of the SUV?
The back of the SUV was closest towards us.
How far from the SUV were you when you first parked at that address?
Probably, it's the length of the driveway. Based on my memory now, I would probably estimate it'd be 60 feet or so.
Did you make any observations of the SUV from that distance?
It was covered with snow, like it's been either sitting outside or driven outside in the snow, so it was exposed to the elements.
What was your next steps?
We waited for Dighton PD to arrive to assist us. Once they arrived, Michael Proctor and I exited and proceeded up the driveway. I told Michael.
Let me stop you with what you said. I want to just know what you observed.
Okay.
As you're walking up the driveway, how close to that SUV did you get at its closest?
At its closest, I got as close as me and the defense table, which is probably 10 to 12 feet.
From the 10 to 12 feet, did you notice anything remarkable about the SUV?
Yes, there was a large piece of red taillight cover missing from the vehicle.
After you made an observation of a large piece of the red taillight cover missing, did you do anything else relative to the SUV at that time?
Yes, I told Michael to get close.
I'm not interested in what he did. What did you do? What did you see?
I just saw the damaged, missing taillight cover. I did not touch it. We did not approach it with physical contact. So,
Did you see where Michael Proctor went?
yes,
How close to the car or the vehicle did he get?
within 3 feet.
Did he ever touch it?
No.
Where did you and Michael Proctor go next?
We proceeded to the front door of the home to make contact with the residents.
And how clearly did you see that missing piece? What's your level of certainty?
100%.
Did you knock on the door?
Yes, I did.
And were you invited in?
We were, but not through the front door due to the weather and the piled up snow. We couldn't open the storm door. Mr. Reed invited us into the home through the garage. He opened the garage door for us and welcomed us inside.
When you went inside, what did you see?
When I went inside, I saw Mr. Reed, Mrs. Reed, and the defendant sitting on the couch.
You've referred to the defendant a number of times as Miss Reed. Do you see the defendant here in the courtroom today?
I do.
And the person you spoke to that morning, can you point that person out and describe an article of clothing they're wearing?
She's sitting in the middle right there in front of me wearing a black suit with yellow-colored metal buttons on it.
When you walked in, did you say that the defendant was sitting on a couch?
She was.
How close were you when you were speaking to her?
Within 12, 15 feet. We were in the same room, in the living room area.
Was Mr. Proctor there?
He was.
Was Mr. Proctor speaking to her?
He was.
Were you speaking to her at the same time or interchanging?
We were both communicating with her, a team approach.
I want to ask you about that conversation you had with Miss Reed. Before I do, Your Honor, may I approach briefly?
Okay?
Exciting sidebar. Yep. I mean, this is pretty standard, what you'd expect it to be. Kind of just walking through the investigation. Yeah. He's a nice lead-in for Proctor because he's the supervisor for Proctor. So, and he was disciplined relating to Proctor. So he's a nice lead-in for Proctor. And Proctor was apparently seen in the courtroom yesterday and seen in the courtroom today. So it seems like the prosecution's looking to call him relatively soon. That sort of makes sense. I don't know that it makes sense to call him right now, though. because I don't think you want to give the defense an opportunity to cross Proctor before the weekend. That's the problem, to my mind, is how do you avoid that problem? So if you call Proctor later today or first thing on Friday, the question in my mind, either way, is can I keep him on direct through the end of the day Friday? That is what I want to do. I do not want to get into cross before the end of the weekend because I don't want the defense to hit him, strong and then have that resonate in the jury's mind all weekend. That is not a great scenario. So I either need to get Proctor completely off the stand by the weekend, and ideally I need to have some other witness to like flush out the memory. And there's no way I have enough time to do that. I can't possibly get Proctor on and off the stand and get another witness on the stand to flush out the memory before the weekend. I just don't have time. So therefore I need to figure out a way to make sure that I don't get into cross with Proctor before the weekend. That is what I would be thinking as the prosecutor. I will sacrifice witness order to make that happen because it is just tactically necessary. And like if I can't call Proctor on Friday, like if the defense stalls with cross to prevent me from calling Proctor, that's fine too. I can call Proctor Monday morning and still do what I need to do. So I call him first thing Monday. That also works. At least I don't have, thoughts of Proctor running through their head the entire weekend. So that is what I am thinking. By the way, in terms of the channel, just want to thank you guys for being here. Thank you for the 368 of you who are currently here. Do appreciate it. If we hit 550 likes on this morning's stream, we will do a merch giveaway. So make sure to hit that like button. Only this morning's stream counts though. So if we don't hit 550, it doesn't roll over into this afternoon. But if we hit 550 likes on this morning's stream, I will do a merch giveaway. And then you can get some cool Karen Reed merch, including Spinny Fan merch, which is recommended. Also, if you wouldn't mind, you could hit that retweet that's in the pinned comment. That would also be nice. Yeah, Proctor's getting 2 full days of cross. I would think so, Bob. I was surprised that the cross wasn't longer in the first trial. The cross was much shorter than I expected it to be in the first trial. I would have anticipated 2 days of full testimony the first time, but that didn't happen for reasons that were beyond me. And I would imagine that they're going to spend more time with it this time. So yes, I think Proctor being on the stand for 2 or 3 days is a very realistic estimate. Yeah, but I don't want the cross to start before the weekend. Because if the defense has any opportunity to cross before the weekend, if it's 5 minutes, I will make those 5 minutes hurt. I will make my first question. Isn't it true that you were thrown off the force and disgraced and all the rest of it? If I have 5 minutes of cross, I will make it painful. Right? I'll make it the worst 5 minutes of your life. So I don't want those thoughts running through the jury's head. I want the ability to control it, and I don't. Yeah, so yeah, that is my problem. If I'm the Commonwealth, defense want to drag it out with Yuri. I don't know that they can drag him out. That's a lot to keep him on the stand for a day and a half. I don't know if they got a day and a half worth out of Yuri. If they can do that, then that works for me. That makes a lot of sense. If they believe they can keep him on the stand through lunch tomorrow, then that works. Then you call Proctor after lunch. You have 4 hours of Proctor where, you go through the good parts of Proctor. You hit him hard on Monday morning. You do a little rehabilitation at the end of your direct. You let the Commonwealth do what it's going to do, or the defense do what it's going to do, and you go from there. Thank you, Dude
All right,
McGuy, for the
so
$5.
Is it appropriate for me to give an instruction right now, Mr. Brennan?
I would defer to counsel.
Mr. Jackson, you want me to give
I'm not asking for
a
one.
humane practice instruction?
Yes.
Yes, all right. So, folks, you're about to hear testimony regarding a statement or statements that were allegedly made by or attributed to Ms. Reed. I'm going to instruct you in more detail at the end of the case about this matter. However, I want you to understand that at this time, as the statements are offered into evidence, that before you may consider the content of any such statement made by the defendant as evidence, you're going to have to make a preliminary determination about whether or not it can be considered by you as evidence at all. In your determination, at the end of the case, you're not to consider any such statement by the defendant as evidence, even though it's presented to you through a witness at trial, unless, from all the evidence in the case, you first determine that the Commonwealth has proved beyond a reasonable doubt that Ms. Reed made the statements she's alleged to have made.
Interesting.
And that she made it voluntarily, freely, and rationally.
That's interesting as a technical legal matter that's the correct legal standard. That's interesting because with other statements that were made, right, when we got to this sort of instruction as it related to text messages, for example, the standard was mere preponderance, as you might remember, right? So before you can consider the text messages, you have to, by preponderance of the evidence, find that they are from that person. So in order to consider the defense statements, you have to consider them, you have to find that they're beyond a reasonable doubt from her before you can even consider them. That's interesting as a matter of law, that's the correct standard. That is interesting to me. I wonder why that distinction exists. That's very curious to me. I didn't know that. Okay, fair enough.
All right, go ahead, Mr. Brennan.
Thank you, Your Honor. Sir, I want you to begin from when you were in the living room, your beginning conversation with the defendant, the presence of both her father and mother. You're with Mr. Proctor.
That's got to be excuse me. That's got to be due to a case somewhere. That has to be because some judge at some point, presumably the Supreme Court of Massachusetts, has said that. That has got to be a judicial decision. That's the result of that distinction. It'd be interesting to try to find that case at some point and read it. That might be interesting as a legal education point. If we can dig up that case, it's got to be the case.
Can you share with us the conversation that you had with the defendant?
Yes. She stated that she's willing to answer our questions, but she didn't want to go into too many details. That's how the conversation began. She provided us the fact that Mr. O'Keefe was hanging out with a friend of his at 5 p.m. at the One Meadows Ave residence, following which he proceeded to C.F. McCarthy's in Canton, where the defendant stated that she met him approximately at 9 p.m. She was drinking vodka sodas. Mr. O'Keefe was consuming Bud Light beer. After C.F. McCarthy's, they proceeded to the Waterfall Grill and Bar. At this point, the defendant was asked if she brought a beverage with her from C.F. McCarthy's to the Waterfall establishment, to which she stated she didn't think so. After the Waterfall, the defendant stated that she dropped Mr. O'Keefe off at 34 Fairview. She was asked if she saw him go in the house. She stated no, she did not see him go in the house. She was asked about the damage to her rear taillight, to which she stated, quote, "I don't know how I did it last night," end quote. Once she provided us with the fact that she dropped him off and never saw him go in the house, she was asked to provide details about her leaving. She stated that she made a 3-point turn and left. She was asked to provide some explanation of how Mr. O'Keefe sustained those injuries that he had. She did not...
Let me stop you there. Did you get an answer to your question about how he sustained the injuries or the details about the three-point turn?
No, I did not.
You mentioned that when you were at Good Samaritan Hospital, you saw blood on the back of Mr. O'Keefe's head.
Yes.
Did you ask the defendant anything about that injury?
Yes, we asked about the injuries that Mr. O'Keefe had, that he had been displaying, and whether or not he had those injuries the night prior at either McCarthy's or Waterfall, to which the defendant stated she didn't see any injuries on him. But then she provided a statement saying that Mr. O'Keefe bumped his head 2 nights prior and asked her about it, which to me seemed kind of strange, but...
Without the commentary. After she told you that Mr. O'Keefe had bumped his head 2 nights prior and that he had asked about it or she had asked about it?
She stated that he had bumped his head 2 nights prior and Mr. O'Keefe asked her about it.
Did she say when Mr. O'Keefe asked her about the bump on his head from the few nights before?
No, she did not.
Did the conversation conclude?
Yes, it did.
After the conversation concluded, what was your next step?
Once the conversation concluded, the defendant was advised that her vehicle is being seized, and her cell phone was also seized.
Were there any other items at that point that you were seizing, other than the cell phone and the vehicle?
Not from that location, no.
Did you have a warrant at that point?
We did not, no.
Did you have authority to seize items prior to having a warrant?
I'll allow that.
Well, what is the process when you want to obtain items but you don't have a warrant? What process do you go through?
You could ask.
We seized them to prevent any alteration, destruction of the evidence that could be contained on those items pending a warrant. They are secured. They're not touched or processed by us. The process of obtaining a warrant includes writing an affidavit justifying.
Yeah, we don't need to hear any of this part.
Understood. Understood. Did you ultimately obtain both the phone and the vehicle?
Yes, we did.
Describe how the vehicle was seized. What happened?
The defendant provided her key card. It's like a credit card size key fob for the vehicle to allow the ignition to start. It was driven onto a flatbed tow truck, secured, and then we followed it from Dighton to the Canton Police Department.
Was video ever provided that showed part of that vehicle being loaded onto the tow truck?
Yes, it was.
Have you ever reviewed that video?
Yes, I did.
When you were at Dighton and the defendant's Lexus was being put on the tow truck, about what time was that?
It was approximately 4:16, 4:15 in the afternoon on the 29th of January, 2022.
Now, you mentioned that you took a cell phone. Are there parts or people, participants on the team that handle that specific type of evidence?
Yes, we have troopers that are specialized, trained, and have expertise in digital forensic analysis, extraction, and processing of digital devices.
Is that something you do?
I am trained in certain portions of it, but I am not an expert like them.
Did you manipulate the phone in any way?
No.
Did you see Mr. Proctor manipulate the phone in any way?
I don't recall seeing that, no.
Before the vehicle was moved or during the loading of the tow, did either you or Mr. Proctor go back anywhere near that vehicle?
We were near the vehicle once it was unloaded, but we never touched it.
Okay.
More sidebar. 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 Sidebar is best bar. Sidebar for you and me.
I believe so, yes.
Anyway,
No,
did you ever go back near the vehicle and touch it in any way?
no,
Did you ever see Mr. Proctor go back near that vehicle and touch it in any way?
no.
You mentioned that the tow was loading the vehicle, the defendant's Lexus, around 4:15.
I believe so, yes.
Did you join the tow truck driver, or did you keep your separate vehicle at that point?
We traveled in my,
I'll allow it.
I drove my vehicle and followed the tow truck back to the Canton Police Department.
Where was Mr. Proctor?
In my front passenger seat.
During that time, had you made arrangements, or did you receive any information about other members of the team engaging in any searches relative to this case?
Yes, I have.
And what did you learn?
I learned that Detective Lieutenant Tully had
I'm going to allow it.
had dispatched other members of our unit to 34 Fairview and other resources from the Massachusetts State Police to assist him in a search for the missing shoe.
Do you know what time those other members arrived or began to arrive at 34 Fairview? You begin your travels at 4:15 p.m. back to the Canton Police Department. Why did you choose to bring the vehicle to the Canton Police Department if the Canton police detectives were not working on this case anymore?
They had a heated storage facility, being the Sally Port. We needed to preserve the vehicle as best we could away from the elements. And it was also in close proximity to our office, also to process the vehicle and get the search warrant from the local courthouse would have been more convenient for us.
Why was a heated Sally Port or a heated garage important to you?
The vehicle was impacted with snow that accumulated, and also from traveling on the highways, it was packed with a shell of snow covering the exterior of it. So it would melt away in the heated Sally Port.
Were you intending on having other resources or other team members or other units available to look at the vehicle at some point?
Yes, we were.
Who were you intending? Who did you expect would have to look at the vehicle in the future?
For one, we'd have to document the exterior of it with photographs. That would be Crime Scene Services section. We would process it for fingerprints, which would be also service the Crime Scene Services section provides. We would, if needed, take swabs for DNA or other latent evidence. So that would be the chemist, as well as if the authority was there to process the internal workings, the computer chips, and the infotainment system of the vehicle. And that would be a digital forensics expert that's trained in that field.
Would an unheated garage or Sally Port impede that?
Yes.
Given that Canton Police Department was not now part of the active investigation, did you have any concerns bringing it to the Canton Police Department?
No.
You said you left Dighton at 4:15. What time approximately did you and Mr. Proctor and that Lexus arrive at the Canton heated Sally Port garage area?
We arrived at the Canton Police Department at 5:30, and the vehicle was unloaded and placed into the garage at 5:35 p.m.
Did you and Mr. Proctor go into the garage?
Yes, we did.
And in the garage, what were you doing?
We helped facilitate
I'm
putting
I'm going to ask you what you were doing and then what you saw Mr. Proctor doing, rather than use we. I want to be very specific about what you did and saw. What were you doing?
I helped put up yellow caution tape around the vehicle to prevent anyone from coming near it and touching it.
Were there any other persons in that area other than you and Mr. Proctor?
There were members of the Canton Police Department.
Did you make observations of the vehicle once you had it in that Sallyport area?
Yes, I did.
You mentioned that it was packed with snow. Was the snow still on it when you brought it into the Sallyport?
Yes, there was.
Did you wipe the car down or clear the
No.
car of the snow?
No,
Did you touch the vehicle in any way with your hands?
no.
Did you ever see Mr. Proctor touch that vehicle?
No, he did not.
Objection.
I'll sustain it.
To strike.
I'll strike that, ask it differently, Mr.
Did you ever see Michael Proctor touch that vehicle while you were in the Sallyport area?
I did not.
How long did you remain in the Sallyport area for, do you know?
We remained in the Sallyport area approximately until 5:51 and change, based on
Okay,
the
that's
best of my
enough.
memory.
After you left the Sallyport area, where did you go?
We left the I apologize.
Go ahead, if you can say first what you did and then wait for the next question, please, Sergeant.
I left the Sallyport area and proceeded inside the Canton Police Department.
Where was Mr. Proctor?
He was with me.
By your side?
Yes.
Did he ever leave your sight?
I'm sure at some point he walked away from me, but I can't. We were traveling together all day.
You went into a different part of the Canton Police Department?
Yes.
Where did you go?
Into the dispatch area, and then the conference room upstairs later on.
Why did you go up to the conference room?
The conference room was provided for us to use as a meeting location. The members of our unit that had assisted at the 34 Fairview Road scene had traveled back to Canton Police, and we were meeting there to share, exchange information based on what we had learned with our portions of the investigation. That way everyone's on the same page at that point.
Did you meet, is this team, is it called a CERT team?
There is a CERT team.
Do you know if the CERT team was the team that went to 34 Fairview?
Yes, I do.
Did you meet with the entire CERT team that night at the Canton Police Department, or some members?
Not the entire team, no.
When you had the meeting in that room, who did you meet with?
In that room, I specifically remember being Detective Lieutenant Tully, myself, Michael Proctor, and other members of our homicide and narcotics section assigned to the Norfolk District Attorney's Office.
Did you discuss the evidence you had to that point?
Yes.
Regarding 34 Fairview Road, did you develop or decide any plans to physically go back to that area?
Yes, I did.
And what was the plan?
The plan was to take shovels and rakes and other gardening equipment and go back to that location to excavate for additional evidence.
When did you make the decision that you were going to go back to 34 Fairview?
It was that evening.
Why did you decide you were going to go back at some point?
During the recall of all the information learned and sharing of that information with other members of our investigative team, it was realized that Mr. O'Keefe was wearing a black baseball hat, and at this point in time, that article of clothing was still missing.
Was there something impeding a full and complete investigation of the scene?
At 34 Fairview?
Yes.
Yes, the heavy, large amount of snow that had accumulated over the last 12 hours or so heavily hindered our investigation of that immediate scene.
When you were debriefed, did you learn the area where the CERT team had spent most of their time searching?
I'm sorry, can you repeat that, sir?
When you were debriefed, were you informed the area that the CERT team spent most of their time searching?
I don't recall on the specifics of it, no.
Now, at some point, did you obtain a registry of motor vehicle record and certificate for the Lexus that you had towed?
Yes, we did.
May I approach?
Yes.
So do you recognize this?
Yes, I do.
And if you can take a look at the following pages. And what is that, sir?
It is the Massachusetts Registry of Motor Vehicle title, history, and registration inquiry for a black and color Lexus LX year model 2022, bearing Massachusetts registration 3GC684, registered to Karen Reed.
Do I move this document into evidence?
No objection, Your Honor.
Exhibit 84.
Thank you. As part of your continued investigation, did you have an opportunity to obtain documents and items?
Yes.
Did you listen to audio recordings that were included statements of the defendant?
Yes, I did.
Did you listen to audio recordings from different sources?
Yes, I did.
What do some of those sources include?
Dateline 2020, Gretchen Voss, Fox 25, various media platforms.
I want to walk through some of the evidence in chronological order of date. So going back to January 29th, 2022, at the hospital you obtained some items.
Yes, sir.
Did you bring those items with you today?
Yes, I did.
I want to talk about the progress of those items from when you first obtained them until today. You mentioned that they were clothes that you obtained at the hospital of Mr. O'Keefe.
Yes, sir.
And you shared with us that they were wet, you put them in bags.
Yes, sir.
That night, where did those clothes go when you left the hospital?
Those clothes, while bagged up, they remained in the back cab portion behind my driver's seat of my pickup truck on the floorboard.
Where did you bring them that night?
That bag containing all those clothing traveled with me around the area as we investigated, and then after the debrief at Canton PD, we brought them directly here to the Canton office of the district attorney.
Did you have those items with you at the Canton Police Department?
They were in my truck. I didn't bring them into the
I see.
office.
They remained in your truck while you were in the Canton Police Department?
Once I placed that bag in the back of my truck, I did not touch until I removed it from the truck at the Canton District Attorney's office to bring it in.
When did you remove it from your truck and bring it into the District Attorney's office?
Probably around 8 p.m. on the 29th of January 2022.
When you brought the clothes inside, where did you bring them?
We brought them to the temporary evidence processing area within the District Attorney's office in the State Police section of the office where we have our desks and workspaces. There's a designated area at the time for evidence processing.
What did you do with the clothes once you got them into the secure area in the District Attorney's office?
Once the clothing was in that secure area, we had to lay them out to dry.
What you did, if you could.
I had to lay them out to dry them. So I took a butcher paper, laid it out on the floor, and each item I removed and laid out onto that butcher paper to dry.
Was anybody with you helping you?
Yes,
And who's that?
Michael Proctor.
Why did you lay out the clothing items one by one separately?
Each clothing item needs to dry naturally and prevent moisture from being trapped. That moisture, if trapped, could develop mold and damage any DNA evidence that we could retrieve. Scientists could retrieve from the item. To prevent that, we dried each item individually, separating each item for better airflow.
How long did it take for those items to dry?
Several days.
And were they in that secure area on the butcher paper for several days?
Yes, sir.
Are there times when that separate area was left alone, nobody watching?
Yes, sir.
Were those clothes ultimately moved from that area?
Ultimately, they were moved, yes.
Did you personally remove them from that area?
No, I did not.
Did you know if they were bagged and put into evidence?
I do know they were bagged and put into evidence.
Is there an evidence locker at that office?
Yes, there is.
Is it a secure area?
Yes, it is.
Does every officer or trooper have access to that evidence room?
No, they do not.
Did you again see those items at a later date?
Yes, I did.
And have you seen those items since?
Yes, I have.
The items, the clothing items you took from the hospital, do you remember what items they were?
Yes, I do.
Can you share with us your memory of what items they are?
It was a two-tone gray sweatshirt, light material sweatshirt. It was an orange t-shirt. It was a pair of blue jeans, a belt, and a pair of underwear boxers.
And did you bring those clothing items with you today?
Yes, I did.
Beginning with the pants, do you have them with you up at the stand, Mr. O'Keefe's pants?
Yes.
Could you produce it, please?
Yes, sir.
Do you have gloves, Trooper Bukhenik?
Yes, I do.
I'd move this item into evidence.
No objection.
With the court's permission, I'd ask the trooper to show the item to the jury.
Yes, go right ahead.
Thank you. May I approach, Your Honor?
Yes.
Did you learn during your conversations with the CERT team and other members of the team that a sneaker was found at 34 Fairview?
Yes, I did.
Have you seen the photographs relative to that sneaker?
Yes, I have.
And you mentioned when you were at the hospital, there was a sneaker? One?
Yes,
Do you have that sneaker with you?
I do.
Could you produce it, please?
Yes, sir.
You want to move this item into evidence?
No objection, Your Honor.
Could I have the court's permission for the trooper to show it to the jury? Trooper, is that the sneaker that was at the hospital when you visited Mr. O'Keefe?
No, so this is the sneaker from 34 Fairview.
Could I have that marked? What, is that a left or a right sneaker, sir?
This is the left sneaker. Excuse me, this is the right sneaker from 34 Fairview Road, Kansas.
Yes, Your Honor.
Sure. If you could put the sneaker back in the bag and let Mr. Brennan bring the bag over, please.
All right, kids. We're having fun. Hope you're having fun. It's just kind of normal routine, what's going on there, stuff. That's pretty good, Mandy. And chat, thank you. That's very nice. Let's see if I can figure out a way to share that with the kids so everyone can see what the funnies are. Yeah, come on. Come on. Don't make my life complicated. Let's just make it simple today. Nice computer. There we go. All right, share, replace screen sharing. There we go. I like this, Mandy. This is very good. Enough to track a cat. I don't know how to define other than enough to track a cat. Robert Gilman, meteorologist. That's very, very good. I like that. I approve. Very, very nice. Thank you for cheering me up. I like that. Very good. Let's see what's happening. All right, let's take a quick look at this case that this person sent me. This person said this is the case that establishes the beyond a reasonable doubt thing with respect to the defendant. So we're going to at least skim this case while we're reading. We'll do our very quick skimming. I don't know if this is the case, but this is what someone said is the case. So we'll take a look anyway. This is from the Supreme Court of the state, Commonwealth versus Tavares, 1982. Let's see what it has to say on this point. Skip the fact pattern, motion to suppress. That's not what we're interested in. Okay, let's see. Kind of threats, taping kit defense coherent, including definitive test, erroneous, voluntary waiver. Okay, voluntariness is of course required. We know that. Blah, 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 blah.
Now, just to make sure that everybody is great and is able to move forward smoothly. These things happen when you have a lot of evidence in the courtroom. So we will see you at 11:30.
All rise, please. Jurors, close your notebooks, follow me.
We're having a little morning break, so it gives us some more time to look at the case law. Let's see if there's anything else from the court before we. Doesn't look like it. This looks like we have a little morning break action for a half hour. So that gives us plenty of time to review case law and see what's going on in this Massachusetts thing. Because, you know, hey, we're a legal education channel, and anytime we can learn something about the law, that's always fun. Okay. Moral certainty. Okay, apparently.
Representative from the defense team speak to Trooper Bukhenik about this issue?
I have no problem with that. Do you, Mr. Jackson?
No, no problem at all.
You will facilitate things. Yes, you may.
Thank you.
All right.
Okay, apparently we're going to have a conversation with the witness while they're on the stand. But apparently the defense has no problem with it, so that's interesting and fun, I guess. All right, noted. That's strange, but I can only keep my mind focused on so many places at once. So let's go back to this case and see what we can do. Reasonable doubt, moral certainty. Apparently, this defendant in this case objected to the moral certainty instruction, which seems like a strange thing to object to. Okay, no. Presumption of voluntariness. Okay. Let's see. This looks like it's going to be what we want it to be. Okay, so here we have what looks like the meat of what the legal issue we're trying to decide at the moment, or the legal issue we're interested in. So this apparently is a summary of the law here. Our humane practice requires that when statements amounting to a confession are offered in evidence, the question whether they were voluntary is to be decided at a preliminary hearing in the absence of a jury, which makes sense. If the judge is satisfied they're voluntary, they're admissible. Otherwise, they should be excluded. If a judge decides they're admissible, he should then instruct the jury not to consider the confession if, upon the whole evidence, they're satisfied it's not voluntary. Well, that makes sense. In the past, we've applied this only to confessions and not to admissions. What the difference between a confession and an admission is, I suppose, is an interesting technical point to be had. However, in recent years, we've questioned whether safeguards might not be required for inculpatory statements that fall short of a confession. Okay, so I suppose that's the difference. An admission is something that makes you look guilty short of a confession. Fine. We see no reason to distinguish. That makes sense. Extending our practice to admissions, we determined that the defendant has not shown substantial likelihood of miscarriage of justice. Blah, blah, blah. Failed to raise the issue of voluntariness. Blah, blah, blah. Since the judge instructed the jury there's a presumption of voluntariness, We think it prudent to elaborate further on the humane practice. The presumption that confession is voluntary merely places on the defendant the burden of going forward at suppression hearing with evidence of involuntariness and does not apply to trial. So the difference between the preliminary decision and the burden of proof at the preliminary stage versus what the jury is required to do, that makes sense. So that I have no problem with. Moreover, even at the suppression hearing, this presumption disappears once defendant has produced some evidence statement was involuntary. Due process requires to persuade the judge it's voluntary. That makes sense. The initial screening, therefore, would conclude before any statement by defendant may be placed before the jury, they must prove voluntariness beyond a reasonable doubt. Interesting. So then there's a footnote, which presumably other jurisdictions also require the prosecution to prove beyond a reasonable doubt the defense statement was made voluntary before it's admitted. Interesting. If the judge concludes defendant statements are voluntary beyond a reasonable doubt, the conclusion must appear from the record with unmistakable clarity. But this is just like, this doesn't feel like the Supreme Court is making this decision for the first time. This doesn't feel like this is a new finding of law. This feels like it's old. And apparently it's so old that they didn't even like provide the citation for the original case that held this. It's like just taken as a given. Because even in the footnote, they don't cite the original case, which, fair enough if it's old enough. If voluntariness is a live issue at trial, the judge must instruct the Commonwealth as the burden of proving beyond a reasonable doubt, and juries must disregard unless met they burn. There's another footnote. Advising the jury finding voluntary serves no purpose. Humane Rule 76. Yeah. That seems like that's a different issue. So that's off, not quite on point. Then they cite some Kentucky case for this proposition, but they don't actually cite what seems to be, there doesn't seem to be a citation in here to like the original Massachusetts case. It's like it's so old, the way this is written, it's like it's so old and so well established that like everyone knows it's true. So this is not the OG of cases on this point, and they don't even cite the OG of cases, which is a little frustrating for our purposes, but that's okay. All right, let's see if we can do any better on terms of case law on this point. I found the instructions from the government. The actual like instructions that the judge is supposed to read, and they cite some cases. So maybe one of those cases cites something that would be more helpful to us in terms of this proposition. I have a 1986 case called Lati. No. There's got to be a case somewhere, right? There's got to be an OJ case. Okay, then let's see. Okay, then there's the case we just read. Here's a case from 1976. Humane practice also applies to statements to private citizens. That's cool. Apparently it is, or apparently this is the OG case. The way this footnote is written in this other thing, this is the OG case. It's not written like that, but okay. Interesting. Maybe this is the OG case, and it's just written weird for an OG case. It doesn't read that way to me, but this footnote seems to suggest it is. Let me read this one, see what it has to say on this issue. See if this provides any further information relating to this question. Okay. Voir dire, confession submitted, voluntariness, preponderance of evidence spoke voluntarily. Defendant argues judge should decide this issue by requiring proof beyond a reasonable doubt. Found Commonwealth was meant burned by preponderance of evidence. Thus, defendant's correct statement should not have been admitted. However, we conclude the judge employed the proper standard, preponderance of evidence, defendant's not entitled to a new trial. In Tarvis, we indicated for the first time, apparently. Fair enough. So apparently that was the OG case. It just was written weird for my taste. I just maybe it was just me, but it didn't read like it was being decided for the first time, but apparently it was. We indicate for the first time the admissibility of defendant's admissions under humane is to be termed by the same standards applicable to admissibility of confession. What I really want is the admissibility of the confession case. That's what I really want. Because they're just saying that an admission is treated the same as confession. So what I want is the OG confession case. So yeah, Tarvis was OG for the proposition that an admission should be treated the same as a confession. But what I really want is the OG confession case. Okay, 77. Let's take a look. For a decision, Commonwealth was required to prove voluntariness only by preponderance of the evidence. Like, let's take a look at the 77 case and see what it has to say. While federal constitutional concern for due process requires only that confession be proved voluntary by preponderance, that sounds right to my mind. Tarvis established Massachusetts' long-standing that's a weird turn of phrase. Tarvis established that Massachusetts long-standing. How can you establish long-standing? Those are like not the same thing, man. That's funny. Retroactivity of the rule we've considered in 3 recent clues is not retroactive. Blah, 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 blah. Yeah, okay, so that part was only perspective. Okay, that makes sense. Let's take a look at the 77 case and see what it says on this point. See if it provides any insight on the issue. Yeah, this is a Massachusetts. Yeah, I thought the federal rule only would be preponderance. That sounds right for the federal rule. So there's got to be a Massachusetts case. There's got to be that says no. For Massachusetts, we're going to require beyond a reasonable doubt as to confessions. And then, of course, later they say, and also admissions too, to the extent there's a difference. There's got to be an OG Massachusetts case. Has to be. It's buried in here somewhere. Okay. This is dealing with the difference between admissions for confessions. Admissions on their face are exculpatory. That doesn't make sense. And then as to admissions, and 77, it was preponderance of the evidence. They changed it later. So, yeah, in 77 for admissions, you only needed preponderance. Let's see if this case does anything for us. 1975. Welcome to case law research and uncivil, right? This is what lawyers do with their time. One of the things they do with their time is like chasing down citations to figure out where things start from and where things end. This is one of the things we do with our time. So you get a little behind the scenes into the less glorious parts of being a lawyer. I remember, for example, when we were chasing down the issue of felony murder for Chauvin, because I refused to believe that was a correct statement of law. Right? I couldn't believe it was true. Like, you can use the underlying assault as the felony and the felony assault. I'm like, no, you can't. And I think I had to read 5 different Supreme Court cases from that state. Like, even the first 4 times I read it, I'm like, the Supreme Court doesn't mean that literally. My mind refused to believe it was true. And like, it was only like the 4th or 5th time I'm like, no, they actually mean this. I can't believe it. So, sometimes you get surprised and you're like, yeah, they don't really mean that. And sometimes they do. Strange things, man. Strange things. Like the first time I heard about pocket service in Minnesota, I was like, what bullshit is this? Surely that can't be correct. And then it was. Sometimes states do weird things and they have weird rules. This is also one of the weird parts about being a lawyer. Is like, sometimes you're like, that can't possibly be true. And so every once in a while it is true. States do weird things, man. There are 50 of them. So sometimes things are strange in ways you do not expect. And then sometimes that even happens with like the Supreme Court, where the Supreme Court will say something and you're like, did they really mean that? When they wrote that, did they actually really mean that, or did they mean something else? Like, yeah, sometimes you have those kinds of questions that pop through your mind. There are 53 states? Yes, that's true. There are 53 states. That's correct. Thank you. Yes, we established the new states of Olympia, Columbia, and Franklin yesterday for our bar exam problem. So yes, we have 53 states now. The tri-state area of Franklin, Columbia, and Olympia, if you don't mind. Yeah. Yeah, that's true. Patient interrogated statements, blah blah blah, blah blah blah, blah blah blah, blah blah blah. Failure to do Miranda, custodial interrogation, blah blah blah, blah blah blah. Okay, since Miranda rules are not based on these statements, the admissibility is governed by due process. Fair enough. Due process is always a good backstop, right? When your other arguments fail, due process is not a bad place to try to go next. A conviction based on whole and part statements that are product of coercion deprives defendant of due process. Fair enough. The convictions are invalid irrespective of truth or falsity of the statements. The use of coercion is forbidden. Yep. Declarations produced by torture or coercion are not premises from which the civilized form will infer guilt. Ooh. There's no easy acid test for voluntariness. Interesting turn of phrase. Judicial determinations must rest on more than mere color matching comparison of analogous cases. That's an interesting statement too. Color matching comparison of cases is kind of one of the things we do with our time. So it has to do more than that. Like, what more is there to some degree? But okay, something more than that. Yeah. It's an interesting turn of phrase too. Totality of circumstances Burden of proof is on the government to show by preponderance of evidence. And then they cite some U.S. Supreme Court cases for that proposition. So yeah, at some point, this is admissions or this confessions. It talks about confessions. So yeah, I'm not 100% sure where the OG case is at this point. I'm not sure it's the case that we read earlier is the OG case. This is just like, at this point, just an interesting academic point. We know what the relevant standard is. We're just trying to figure out where it came from. Spinny fan is still spinning, by the way. Maybe if I just try to do a Google Scholar search and see if I can come up with anything. Let's just go back to square one on Google Scholar and see if we can get anywhere. All right, so I want to limit myself. No thanks. I would like to select Massachusetts-based courts, please. Preferably, I would like the highest court of Massachusetts would be nice. So let's limit ourselves to the Supreme Judicial Court. And let's try confession beyond reasonable doubt. And also, the issue is voluntariness, which I am not going to be able to spell correctly. Voluntariness, that is not even close to correct. Is there a Y in there? Yeah, probably. No, it's an I. Okay. Let's see. So it cites the Taravis case we read earlier. Let's just pull up a couple cases in order and see if we get anywhere. The Dead Weasley, your bot reminded me on YouTube takes a cut. Here's the rest. Thanks for your coverage. Here's hoping defense gets back that first trial magic. I hope so too, man. I hope so too. Yeah, let's see if we get anywhere with any of these citations. Okay, blah, blah, blah. Voluntariness and circumstance. Inquiry statement is made voluntary, same as arises. Confession was made. In custody statements. Mid finding. Okay, voluntariness of statements made during custodial interrogation without counsel. The state bears the burden of proving intelligence is voluntary. A confession can be voluntary only in a legal sense if they understand the import of Miranda. Police officers can infer that understanding from suspects' behavior. There's no evidence of coercion, duress, or improper suggestion. No evidence which will lead the officer to proceed with greater caution. Fifth Amendment is prophylactic. Yeah. Here, the goal was amply served. Requirement knowing intelligent waiver was met. The jury chose to believe the claim he complained of non-comprehension. Will not interfere with the choice. The waiver of rights must be knowing and intelligent. Does not mean with a hindsight conviction would not have chosen to talk to the police. Yeah, that's for sure. They must be found to be knowing, voluntary, free. Such findings support no error of coercion. In all of our discussions, we've refer to the statements without attempting to classify them as admissions or confessions. That's unnecessary because of the language in Miranda. Yeah, it's unnecessary as a matter of federal law. I think that's true. I'm not aware of any distinction in federal law between these two things. This seems to be a Massachusetts created distinction in the first instance. A statement is a statement. Miranda applies to any statement, custodial interrogation. So, Miranda doesn't draw these distinctions. But Massachusetts wants to draw these distinctions. To the extent it wants to give more rights, it can do that. It's not a problem to draw those distinctions. It's just, Massachusetts is doing Massachusetts. They can always give more rights than the federal law requires. In charging a jury, they found they didn't inform them. They should disregard the statements. Did not intelligently volunteer the actions by judge or not put at issue. The question was alluded to but not decided in the event voluntariness of statements. The practice has long been established in the Commonwealth and was statements amounting to a confession. The question of whether voluntary is to be decided at a preliminary hearing. If they're decided they're voluntary, they're admissible, otherwise excluded. If the judge decides they're admissible, he should instruct the jury not to consider the confession unless it's a voluntary act. And then there's a citation to a 1959 case. The rabbit trail of cases continues. Apparently, there's an 1885 citation. Maybe we're going all the way back to 1885. That'd be fun. 1885 cases for the win, man. If it's established in 1885, no wonder the court treated it as like the water they're all swimming in, right? If this OG case is 1885, that makes a lot of sense why everyone just treats it as basically a given, and then we don't have to cite it because we're just going back to the beginning of time. Yeah. Preliminary hearing, decisions relating who may not have been overruled. There have been a number of more exceptions. Something dealing with youth. Same standards for admissions versus confessions. Blah, blah, blah. Blah, blah, blah. The judge didn't distinguish between admissions and confessions, which he wasn't required to at the time. Yeah, all right. So that doesn't tell us what we want to do. Let's go back to 1885 and see if it gets us anywhere. We actually don't. It doesn't actually have the citation that far back. It doesn't actually have the 1885 case on Google Scholar. So no 1885 case for us. How about 1959? Can we get anywhere from that? Supreme Judicial Court of Massachusetts, Middlesex. Okay, size confession. It's cold. They decide that the ultimate decision is right, but come to a contrary opinion. Okay. Blah blah blah. Humane practice. Jared. Blah blah blah. Okay. It just kind of refers to it without giving any further information, so that doesn't help us. Okay, we read that case already. What else? Edwards. Let's see, does that get us anywhere? Miranda waiver. Beyond a reasonable doubt, 1983 case. Well, as to a Miranda waiver, beyond a reasonable doubt. Interesting. So is that sort of where it starts? Yeah, that makes sense. It would have to be a post-Miranda case. It would almost certainly have to be a post-Miranda case. Yeah, it doesn't really make 100. I mean, it's possible, but it doesn't make sense that it makes more sense that it's a post-Miranda case versus an 1880 case. It's possible it's an 1880 case, but it makes more sense post-Miranda. The defendant argues that his use of marijuana, consumption of alcohol, and failure to eat before talking prevented him from making a knowing and voluntary waiver. The judge assumed defendant had been smoking marijuana and drinking. Nonetheless, he found the defendant could and did make a knowing and intelligent waiver. So you might be drunk and high, but voluntary enough, man. The defendant also asks us to hold the Commonwealth's burden of proof on the issue of waiver as proof beyond a reasonable doubt. We left the issue open in 1982. Since the defendant's statement may not be placed before a jury unless the judge concludes the Commonwealth proved voluntariness beyond a reasonable doubt, we think admission, yeah. So it just looks like it's some Massachusetts state-specific stuff. It's kind of interesting.
No, I had brought
I hope you enjoyed that. I hope you enjoyed that slightly deeper dive into Massachusetts state-specific law. Always fun to try to learn something. Hopefully that wasn't too boring for some of the people in chat. I know it's not as thrilling and, action-packed, but might as well try to learn something of legal value during the break.
All right, thank you.
Thank you for joining me, and thank you for hitting that like button. By the way, if we do hit 550 likes on this morning's stream, there will be a merch giveaway. So make sure to hit that like button. If we hit 550 likes, we will have some merch giveaway, and it will be fun. Morning stream only. Got to hit 550 likes on this morning stream.
All right, so the court adjourns entry.
Spinny Fan is the best juror. That's all I know for sure. Spinny Fan always is correct in its judgments. Spinny Fan is infallible. Got to get that airflow going, prevent the air from becoming too stale. Got to have a Spinny Fan. Got to have Spinny Fan in court. It's necessary.
Court is back in session. You may be seated.
All right, are you all set, Mr. Brennan?
I am, thank you, Your Honor. May I?
Yes.
So Sir, when we left, we were discussing Mr. O'Keefe's sneaker that you retrieved from the Good Samaritan Hospital.
Yes, sir.
Would that be his right sneaker?
It would be his right sneaker.
Do you have that sneaker with you today?
I do.
And again, could you open that bag and show that right sneaker to the jury?
Yes, sir.
Is that the sneaker you retrieved from the Good Samaritan Hospital?
It is.
I'd move that into evidence, please.
Okay, any objection, Mr. Jackson?
No, Your Honor.
All right, thank you.
Trooper Bukhenik, there are two more items. I'm sorry, Your Honor.
Okay, go ahead.
Thank you, Your Honor. Trooper Bukhenik, there are two more items that you retrieved of John O'Keefe's clothing from the Good Samaritan Hospital. Did you bring those two items with you?
Yes, sir.
Are those two of the items that you laid out on butcher paper to dry?
Yes, they are.
Were they ultimately bagged and put into evidence?
Yes, they were.
And did you bring Mr. O'Keefe's T-shirt?
Yes, I did.
Is it placed in an object so it can be seen?
Yes, it was.
What type of object?
It's a transparent plastic sheet.
I would move the T-shirt into evidence.
No objection, Your Honor.
With the court's permission, could Trooper Bukhenik show it to the jury?
Yes.
Ooh, the shirt's in plexi now. Ooh, fancy, fancy. Fancy,
Show the back
fancy.
as well, Trooper. Thank you.
Mr. Brennan, could you help assist the court reporter with that, please?
Of course.
Exhibit 87.
Just place it on that side.
Yeah, that'd be great, thank you.
Who paid for that framing? How do you get that framed? That's actually a reasonable question, actually. Who did it? It's actually a reasonable question. Did
And
the
Trooper
police
Bukhenik,
do
is
that?
your
If so,
last piece
how?
of item of Mr. O'Keefe's that you took from the Good Samaritan Hospital.
Yes, it is.
And what is it?
It's the sweatshirt.
I'd move that into evidence, Your Honor.
Sweatshirt also in a frame.
The court's permission.
Yes.
Very exciting.
Could you show the backside, please?
I mean, you got to give credit where credit's due. It does make a hell of an impression, putting in the plastic sheeting, man. That is very theatrical. You got to give it credit for being memorable.
May I approach?
Yes, thank you. Next exhibit, please, Madam Court Reporter.
Exhibit 88.
Thank you.
Your Honor, as to exhibit 88, maybe approach the briefing.
I'm sorry?
Maybe approach the briefing.
Oh, okay.
All right, sidebar time. Sidebar time's glorious time. Good times. You got a signed jersey like that? I believe it. It's just I'm trying to think if I've ever seen that before in a trial. I'm not sure I have. And who does that work? Is who actually prepped it that way? Presumably some tech in a lab somewhere at the prosecutor's office or something, but I'd like to know how that was done technically, just for my shits and giggles. How can we be on schedule with all the wasted time? That's a pretty good question. Thank you, Geraldine, for becoming an uncivilian. We do appreciate everyone who hits the join button. It is only 99 cents a month to become a member of the channel. And it's extensively appreciated. Thank you. Also, we, of course, appreciate super chats. Those are always fun and appreciated. Put a little donate QR code up there if you want to donate to the channel. Going world record for the amount of sidebar breaks. I don't know about that, but certainly have a lot of them for sure. Yeah, where is the chain of custody? That's a good question. Yeah, I have questions relating to chain of custody for the plexiglass too.
Jurors, every piece of evidence that you're getting is recorded, and we have to keep a very clear record. So sometimes we spend time that may seem like a waste of time to you, but it's very, very important for the case. So we do appreciate your patience. All right, go ahead, Mr. Brennan.
Thank you. Trooper Bukhenik, you shared with us that you met with some of the members of the state police that night and then returned to the Norfolk County District Attorney's office to put the clothing on butcher paper, you called it. What was your next step in your investigation?
We met and discussed the next steps. My decision was to go back to 34 Fairview and excavate for the missing clothing item, being Mr. O'Keefe's hat. There was also plans to start writing search warrants.
Did the weather get better over the next couple days?
The weather did take a turn for the warmer temperatures, yes.
Did you return to Fairview a few days later on February 3rd?
Yes, I did.
Was that the first time you personally had visited 34 Fairview?
Yes, it was.
When you went to 34 Fairview on February 3rd, 2022, do you remember about what time in the morning you went?
Sometime between 8:30, 9 o'clock, maybe 9:30.
When you went there, did you travel with anybody?
Yes.
Who did you travel with?
It was other members of my unit and a member from crime scene services.
Did you all travel in the same vehicle, or did you meet there?
We all traveled in our own issued cruisers.
Was this a planned search or a planned excavation on February 3rd,
Yes, it was.
2022?
Yes, it was.
Who was there at the scene, 34 Fairview, with you?
It was Trooper DeChico, Mike Proctor, and Trooper Evan Brent.
And Trooper Evan, last name?
Brent.
Brent. Was Trooper Brent the photographer?
Yes.
What type of tools did you bring when you went to 34 Fairview?
We brought snow shovels, garden shovels. I brought like an E-tool, military-style E-tool.
Was there
A
still
what?
some snow on the ground?
There was, yes.
Did you and the members of the group begin to look for any evidence?
Yes, we did.
Were you looking on the street, or did you move to more on the grass?
Objection, Your Honor.
Ask it differently.
What area were you focused on at this point?
We were focused on the lawn portion of the property by in the vicinity of the flagpole the fire hydrant, and along the edge of the asphalt.
Did you see a berm, an asphalt berm separating the concrete street and the yard?
Yes,
Were you looking anywhere near the area of the berm?
we did, yes.
Were you looking anywhere on the street?
The street was plowed, but portions of the street still had remnants of snow, so we did check that area, but it was much easier to identify anything because it was clear of snow.
Where was most of your focus?
On the lawn.
As you worked your way through the lawn, did you or members of your team come across any items that you believe to be evidence?
Yes.
I'm going to ask you to produce some of that evidence to us. Beginning with 535, did you find a number of pieces of plastic?
Yes.
Could you produce 535?
Yes, sir.
Let me just ask you a couple questions before you open that. If somebody identified an object that they believed to be evidence, what was the process for handling it?
On this day, we identified an evidence. The process would have been documenting each item that was located with photographs. Then one of the members of the individuals present would bag each item into a paper bag.
When they were bagged, would the person bagging them use any type of protection like you're using?
Absolutely, every time.
After the items were bagged, was the bag sealed?
Eventually it was sealed, yes.
When you say eventually, what does that mean?
Once it was, all the items were inside and it was brought back to the office, it would be sealed, signed, completely filled out with all the pertinent information on the back.
Could you open that bag?
Yes, sir.
Before you take the pieces out, I'm asking you to look in. Do you recognize those pieces?
Yes, I do.
What do you recognize them to be?
I recognize them to be the items that we recovered from the lawn area on the left side of 34 Fairview Road on February 3rd, 2022, during the planned excavation of the property.
And were they photographed before they were put in that bag?
They were.
Your Honor, may I approach before Trooper Bukhenik
Yes.
opens that bag or goes through it?
Did you show Mr. Jackson?
I am sorry. Hand you a series of photographs. I'd ask you to take a look at them, see if you recognize them.
I do recognize them.
And what is in those photographs?
The photographs depict items collected from the lawn at 34 Fairview on February 3rd, 2022.
Do those particular photographs correspond with the pieces of items that are in that bag?
They do.
I have moved this series of photographs into evidence.
Any
No
objection?
objection.
Okay. We'll knock them separately, please.
Six. Those items, were they eventually sent for analysis to a Massachusetts State Police lab?
Yes, they were.
When the laboratory received those items, are you familiar whether they marked them with a label or a number for identification?
Objection, Your Honor.
I want to know that.
Yes, they mark each item individually.
Do those items have markings on them reflected by an item number?
Yes, they are.
When you refer to a piece, will you refer to that item number that is on any individual piece?
Once it's labeled, it is identified by that individual piece, by that designated label.
So if there's any numbers written on any of those pieces, was that written by you?
No.
Would that have been written by somebody else after it was sent?
Yes, at the lab.
Okay. If we can begin, if you can begin to take the pieces out so we can show them to the jury. And does that have a number on it or a tag?
Yes, it does. This is item 22-02-184-7-8, also alphanumeric A.
May I approach, Your Honor?
Yes.
Thank you.
These two are taped together.
When you found them, were they taped together?
No. They're taped together by the lab. There's also a canister labeled debris collection. That number is 22-02-184-7-8.1. This is 7-8G. This is 7-8N, as in November. There are also items too small to label with a letter and number. Those were put into a bag like this. Almost looks like a stamp bag, wax stamp bag.
Are those all the items in that bag?
Altogether, there are, it does look like those are all the items. Some of them are inside the canister that I pulled up.
Understood. You know how to move those items into evidence, please?
Exhibit 95.
Sir, you mentioned that there was a trooper there photographing the evidence.
Yes, sir.
Did the photographer take a photograph of the items in place when they were found, or were the items moved to a different location before they were photographed?
That day, every item was photographed where it was found.
With the court's permission, I'd like to show a number of exhibits to the jury.
Okay.
And starting with Exhibit 89, which is P490 7690. Trooper, is that one of the items you found that morning?
Yes, it is.
Do you know where, in relation to the fire hydrant or the flagpole, this item was recovered?
It was in the general vicinity between the flagpole and the fire hydrant. The area we were excavating was approximately 40 to 50 square feet in area.
Mr. Brennan, can that be expanded, please, so that the jurors can see what we're looking at?
Thank you, Your Honor. Is the item that you recovered on top of that leaf?
Yes, it is.
Thank you. If I could next show Exhibit 90, which is P492 7692. Before we close up, sir, is that the fire hydrant that is at the corner of 34 Fairview Road?
Yes, it is.
Could we close up, please, on that? Why is there a ruler on the ground?
The ruler is utilized to help put the item to scale by the photographer from Crime Scene Services. They utilize these measuring rulers for scale of the item that you're looking at. Sometimes it's hard to depict how large an item is if there's no reference point.
Could we do a little bit further view to show the fire hydrant? Thank you. Is that where this piece of evidence was found, in that exact location?
Yes, sir.
Thank you. I'd like next to show to the jury Exhibit 91, which is P515 7721. Do you recognize that piece of evidence?
Yes, sir.
Could we zoom in, please? Is that the same piece of evidence that is depicted in Exhibit 89, P490 7690, a different angle with the ruler?
Yes, sir.
Thank you. If we could have Exhibit 92, please, which is P493 7694. Could you zoom in, please? Is that piece of evidence in the bag that you've provided as evidence, physical evidence?
Yes, sir.
Was this found near the area of the other pieces?
Yes, it was.
If we could show Exhibit 93, P507 7711, please. Could you zoom in, please? How long did you spend that day looking, you and the team, for pieces of evidence?
I was probably 45 to an hour.
And finally, if I could show Exhibit 94, P503 7707. And could you zoom in, please? And this piece of evidence, where in relation to the other pieces was this found?
In the same vicinity.
Thank you. If you could take that down, please. When you were searching, did you find any item near the street area?
Yes, we did.
What did you find?
A black plastic drinking straw.
Could you retrieve 536 for us, please? I'd move this piece of evidence into evidence.
No objection.
All right.
May I approach, Your Honor?
Yes, let's get it marked.
I'm sorry, Your Honor?
Let's wait till it's marked.
Exhibit 97.
Thank you.
Showing a photograph, do you recognize that, sir?
Yes, I do.
What's it a photograph of?
It's a photograph of the black drinking straw that we found at 34 Fairview on February 3rd, 2022.
What location did you find it in?
It was close to the paved berm on the street.
This is after the street was plowed?
Yes, it was.
I'd move this into evidence as an exhibit, please.
Okay.
No objection, Your Honor.
Exhibit 98.
I'd ask you to open this and show it to the jury.
Yes, sir.
With the court's permission, I'd like to show Exhibit 98 to the jury,
Okay.
and that is P4887688. Sir, could you look at that photograph? And Ms. Gilman, could you close? Do you recognize what's in that photograph?
I do.
And what is that?
That is the photograph of the straw we picked up from the street in front of 34 Fairview Road.
Could we zoom out a little bit, please, Ms. Gilman? Is that the area where you or your team recovered that straw?
That is exactly where it was found and recovered from.
That photograph doesn't show much of the grass area. How far is that area from the fire hydrant?
It's probably, with my estimate, 15 feet, maybe 20 from the fire hydrant. It's probably 15 to 20 feet, if I had to estimate.
Thank you. You mentioned that one of the items that you went back to Fairview to try to find was a hat. Why were you specifically looking for a hat?
I had learned that Mr. O'Keefe was wearing a black baseball hat the night prior to the incident. So with us recovering the clothing from the hospital and the hat was not part of that pile of clothing, we needed to see where the hat was. That could have been a lead. That could be a clue of where Mr. O'Keefe was last prior to being discovered.
Did you or the team ultimately find a hat that morning?
Yes.
Could I have you produce 537?
Yes, sir.
All right, I've moved that item into evidence.
No objection.
So this is going to be 96.
Thank you.
Exhibit 96.
Thank you.
With the court's permission, Trooper Bukhenik, could you open that and show it to the
Yes.
jury? Was that item photographed?
Yes, it was.
And when that was taken from the scene, was the same method used of using gloves and putting it in a bag?
Yes, it was.
When the item was it photographed in the place that it was found?
Yes, it was.
May I approach, Your Honor?
Yes.
Thank you. Sir, I'm showing you a series of photographs. If you take a look at it, the first one, do you recognize that photograph?
I do.
What is it?
It's the accumulated snow that was being excavated at the scene where we located Mr. O'Keefe's hat.
And the second photo?
The second photo is a close-up of Mr. O'Keefe's hat, flattened and frozen to the ground with portions of it exposed from underneath the piled up snow.
Third photo?
Third photo is also of the hat once it's been removed, and you can see the thin blue line, American flag, on the front of the hat, and the Nike swoosh on the brim.
And the fourth photo, please.
And the fourth photograph is also a close-up of the top of the hat with a scale ruler next to it with grass showing from underneath the hat.
I'm going to put these back in the order you identified them. Where I move these four photographs into evidence.
Okay, any objection?
No objection, Your Honor.
Do you want them as 4 separate or A, B, C?
A through 99D, so marked.
Thank you very much. Thank you. With the court's permission, I'd like to show these photographs to the jury.
Yes.
Beginning with 99A, P526, 7733, please. Could you close up just a little bit, please? Sir, can you describe what you see here?
Yes, that's the excavation track by one of the members at the scene. You could see the hat frozen flat to the bottom, or on the bottom of the snow, right on top of the grass. It was under approximately 1.5 feet of snow that had accumulated in the area.
We could next show 99B, P527, 7735.
This is again the close-up of the frozen flat hat to the grass at 34 Fairview Road.
Next is 99C, P529, 7739, please.
Once pulled out and flipped over, again, this is the same hat belonging to Mr. O'Keefe that was discovered frozen flat to the grass at the scene.
Thank you. You can take that down, please. Did you search the entire front lawn at that time?
No, we did not.
And we can see from those photographs, is there still snow in that yard?
Yes.
As you continued your investigation, did you continue to go back to Fairview over time?
Yes, based on the amount of snow still present and the fact that we were finding pieces of broken taillight and glass at the scene, and items that we did not expect to find, like a cocktail glass straw. I directed my members to go by the scene every day as the temperatures rose. Snow would expose more evidence on the lawn, and with the hopes of finding each and every item that was present.
On February 4th, the next day, 2022, did you receive a call?
Yes, I did.
Not what was said, but who was that call from?
I believe it was,
I don't want you to guess if you don't know. Was the person a member of any group?
yes,
From what group?
it was Canton Police.
As a result of receiving a call from the Canton Police, or someone from the Canton Police on February 4th, 2022, did you go anywhere?
I was already en route to 34 Fairview to conduct a directed check of the area.
When you say directed check, do you drive by every day on your way to work?
I told my members on every day to work and home to make sure someone's checking the lawn to make sure that any evidence that exposes itself through the melting snow would be identified and collected.
As you were on your way there, you received a call from someone from the Canton Police?
Yes,
Did you arrive at 34 Fairview on February 4th, 2022?
I did.
When you got there, did you see any more items?
Yes, I did.
How many?
One item, a larger in size red taillight piece had revealed itself, and it was collected.
Could you produce 710, please?
Yes, sir.
Is that 710, sir?
7-10, yes, sir.
I'd move that item into evidence, please.
No objection.
Exhibit 100.
With the court's permission, could Trooper Bukhenik open the item and show it to the jury?
Yes.
Thank you. Did anybody photograph that item where it was found?
Yes, there was a photograph taken.
Did you take the photograph?
No, I did not.
How did you receive the photograph?
It was attached to the Canton Police reports that were provided. Canton Police documented that item in place.
May I approach?
Yes.
Showing you two photographs. The first page, you recognize that item?
Yes, I do.
What do you recognize that to be?
That was the item I collected on February 4th at 34 Fairview Road, which I was just showing to the jury.
And the second photograph?
The second photograph is a zoomed out general vicinity photograph of the same item from 34 Fairview Road, the lawn area, approximately 7 feet from the roadway.
I'd like to move these into evidence. A and B. Court's permission.
Any objection, Mr.
There's
Jackson?
no objection, Your Honor.
Exhibit 101A and B.
With the court's permission, I'd like to show those photographs to the jury.
Yes.
P46, please. Is that a photograph of the item you just showed the jury, sir?
Yes, it is.
And where was it in relation to the other pieces that you had found on February 3rd?
It was further to the right. If you're looking at the property, if you have the fire hydrant on your left, it was further to the right, on the right bank of the snow that was melting on the lawn.
Is that on the lawn or on the pavement?
That's on the lawn.
And could we show the close-up, please, P47? Thank you. You could take it down, please. When you recovered those items, did you go through the same protocol of gloves and bags?
Absolutely.
Did you return to 34 Fairview on February 10th?
Yes, I did.
Was the snow in a different state than when you last left it on February 3rd?
Yes, it had receded significantly.
When you went back on February 10th, were you with anybody?
I believe I was with another trooper.
Do you know who that was?
I don't remember. I'd have to refresh my memory.
Was it Michael Proctor?
It might have been, yes.
Could you produce 7-11, please?
Yes, sir.
Does that bag contain some of the items you found on February 10th at Fairview Road?
Yes, it does.
I'd move that into evidence, please.
No objection, Your Honor.
Okay. Exhibit 102.
Can you describe generally the size of the items in that bag?
Can I open it?
Please.
Generally speaking, there's 6 plastic pieces of clear and red and black items that are in size approximately to like a $50.
Without going through every one of them, can you just pull out one red and one clear to show the jury a representative sample of what's in the bag? In total, there's 6 items in that bag.
In total, there are 6 items in the bag.
When you retrieved those items, did you use the same protocol of gloves in a bag?
Yes.
Did you photograph these items when you took them?
Not on this day, no.
Why not?
We had been to the scene so many times. It was the same general vicinity, and we just made the decision not to have crime scene come out to photograph these six pieces.
Were they in any remarkably different position than the other pieces? Anything that stood out, or were they in the, let me rephrase that. Where were they generally in relation to the other pieces that you had found?
They were all in the general area where the other pieces had been located. It was on the left side of the lawn, but near the flagpole, between the road and the home.
Was there another group of items that you found that day that you put in a separate bag?
Yes.
Could you provide us? May I approach? I'm not sure if I've marked this one for evidence or
Yes.
not. Thank you. Thank you. Could you produce 7-12, please?
Yes, sir.
I'd move this into evidence, please.
No objection.
With the,
Exhibit 103.
with the court's permission, could Trooper Bukhenik open the bag?
Yes.
In that bag, are there different types of items? The items you showed us before appear to be plastic.
Yes, these items are packaged in wax paper. There's 14 pieces in total, and these items contain glass and plastic fragments, some of which are also within like a cylindrical tin container that you saw earlier.
Could you show us some of the glass pieces, please?
Yes, sir. I'm gonna have to open the wax bag.
Please. Could you stand so the people in the back can see? Thank you. Were there a number of different items inside that are inside that bag that you found that day?
Yes, there are a number of glass pieces taped and labeled for identification at the lab and mechanically pieced together to form this one piece in my right hand, and this is one solid, thick piece of curved glass in my left hand.
And again, is this February 10th, 2022?
Yes, it is.
The last evidence bag, you said that you did not photograph where they were found. Did you photograph where these pieces were found?
No, I did not, no.
Any different reason than the last bag?
No.
Do you have a memory of where these items were found in relation to the items in the last bag?
Yes, they were all in the general vicinity where all the other taillight pieces were located, as well as the baseball hat.
How much snow was on the ground at this point?
Most of the snow had melted. There might have been some areas that was still present because of the excavation that took place. So very little to no snow was present at this point in time.
May I approach, Your Honor?
Yes.
Is that all the pieces that you have that you were part of finding or retrieving from 34 Fairview Road related to plastic or glass discovery?
Yes, sir.
Did you continue to work on this case?
Yes, I did.
At some point, did you receive video from a number of different locations?
Yes.
Where were you part of retrieving or receiving video from?
I was part of retrieving and receiving video from C.F. McCarthy's, the waterfall. There was also video that was collected from other agencies and entities.
Did you seek a search warrant or video evidence from a company called Ring?
Yes.
For what location?
For the Meadows Ave location, Mr. John O'Keefe's residence.
Did you receive video from Ring, directly from Ring?
Ring sent over files with Ring video.
Was that by link, by a computer?
I'm not sure how it came in. It was via the internet.
Did you view all of the files that were produced by Ring?
At some point, I've reviewed all the files, yes.
Was that pursuant to a subpoena?
I'm sorry?
Were the Ring videos produced pursuant to a subpoena?
Through the search warrant, yes. We
Search.
requested it through the search warrant. That's the way that these providers, service providers, respond to court legal service.
Were you aware that some cruisers or the cruisers at the Canton Police Department had dash cam video?
Yes, I am aware of it.
Did you obtain and review video?
Yes, I did.
Have you seen other video from the Canton Police Department?
Yes, I did.
At some point, were you asked if you would consent to provide your DNA?
Yes, I was, yes.
Is that uncommon in investigations?
It's not common, but situations do arise where you're asked to do that. So it's not the first time that's happened, but it has happened before where a law enforcement individual officer has to provide DNA, and they consent.
Did you?
Yes, I did.
Did you review any other materials in this case? Did you review any reports?
I did review reports, yes.
Did you write reports in this case?
Yes, I did.
Now, I want to ask you about Michael Proctor. You had told us that you were
Okay, this should be
working on this
good.
investigation with him.
Yes,
This
I
might be
was.
good.
Are you still working on this investigation with him?
No, I am not.
Let's go.
You were Michael Proctor's supervisor?
Yes, I was.
When you work for the state police, you have a personal phone and a phone that is provided to you by the state police?
Yes.
The state
All right, baby. All right, baby. We're going to do the spicy part of this thing. Yeah. We got to talk about Proctor. We got to talk about him. We got to talk about the fact he was disciplined related to this. Get into the Proctor stuff. Get that going. Yeah, let's go. Let's go for spicy. It's spicy time. It's spicy time with Uncivil. Spicy time for you and me. Spicy time together.
police phone, is that a work phone?
Yes, it is.
What type of information do you receive on that phone?
You can receive communications via email, text message, cell phone, tower, voice communications.
Okay, do officers communicate with each other at times on those work phones?
Yes, they do.
And during that time, did you have a work phone that you were using for communications?
Yes, I did.
At some point, did you receive, or were you placed on an email chain that included Michael Proctor and others?
I believe it was a text chain.
I'm sorry, a text chain.
Yes, yes.
Were you included on a text chain involving Michael Proctor and others?
Yes, I was.
Did you receive a text or a text chain from Michael Proctor and other people?
Yes, I did.
And when you received a text, do you remember where you were when you received the text chain?
The specific one you're referring to, I was at the Logan Airport working a traffic detail.
When you received that text or text chain, did you respond?
Why were you working a traffic detail, Sergeant? Were you being punished? I think you were probably being punished.
I acknowledged the text. I did not respond through with verbiage.
And then during that text chain, did you look at the entire text chain?
No, the text message came through on my Apple Watch as I was controlling traffic. I glanced at it, took part of the information that came through, and acknowledged it with a thumbs up emoji, indicating that I read it.
At some point, did you learn everything that was on that text chain?
Yes.
And as a result of that text chain, was there an investigation?
There was.
And during that investigation, you were Michael Proctor's supervisor?
I was.
After the investigation was done, did the state police make any finding against you for that text chain?
Yep.
Yes. There were 2 sustained findings as a result of that investigation.
Did you initiate that text chain?
No, I don't believe so.
You did react with a thumbs up?
I acknowledged the text message that he sent, or portion of the information that came through on my watch.
And the 2 sustained findings against you, were one of them for failure to adequately supervise?
Yes.
And the other, was it regarding a routine or regular review that it didn't consider that text chain?
Objection, Your Honor.
I'll rephrase.
Okay.
That second sustained finding, was it regarding a review of the performance level of Mr. Proctor?
That's correct.
Sustained is to full.
Was there a second sustained finding?
Yes, there was.
Did it relate to the review process of a subordinate?
Objection.
Sustained is to full.
What was
What did
that
it relate
second
to?
sustained finding about?
The accuracy of the review of the quarterly performance evaluation.
You said quarterly. How often would you write reviews for subordinates?
Every 90 days.
Was there any other sustained finding against you?
No.
Was there punishment in light of those 2 sustained findings against you?
There was.
And what was that punishment?
I lost 5 vacation days.
Do you
Aww.
presently work in the Homicide Division of the Norfolk County District Attorney's Office?
I do.
Are you currently a sergeant?
I am.
Fewer trips to Tahiti this year, I
Have you
guess.
ever reviewed that entire chain that was at issue?
Only through the documents provided for me during the internal investigation.
May I approach, Your Honor?
Yes.
May I stand here?
Sure.
Sir, I'm going.
Turtle Boy apparently on chat. Turtle Boy on X is claiming the Commonwealth will not be calling Michael Proctor, Brian Tully, Brian Higgins, Brian Albert, or Colin Albert. They're trying to hide their most damaging witnesses. He goes on to say if the defense chooses to call them, they'd be more limited in what they can ask if they can cross-examine them. That doesn't make any sense. That last part doesn't make any sense. First of all, in Massachusetts, it's unlimited in scope, which is an unusual aspect of Massachusetts rules. Most states are at least formally in form limited to cross, that you can only ask on scope. The scope of it is limited to what's on direct, but Massachusetts is unlimited scope on cross. So you're allowed to ask anything on cross, which is a bit of a deviation from the standard rule. Now, as a matter of practice, incidentally, by the way, that's not that unusual. Like most jurisdictions, as a matter of the rule, allow limited scope. But I think it's correct to say most judges tend to allow larger scope than the rule technically allows for. But Massachusetts is unlimited in the first place, so it doesn't matter. And as to the scope of direct, yeah, there's no limit. Why would there be? There's no limit on direct. So there's no reason why they'd be more limited than what they could ask if they crossed. That doesn't make sense. They'd only be limited in some other way. They'd be limited by some other ruling. So I don't understand why Aiden's saying that. That doesn't make sense to me. They should be unlimited in scope unless there's some sort of motion limine or otherwise that would apply. They should be able to ask the same questions they would in any event. As to the Commonwealth not calling these people, that seems like, I mean, I certainly not understand them not wanting to call some of these people to the stand, but the defense will, I would imagine, and the defense is going to make it painful. Yeah, I mean, it seems unlikely that they wouldn't call Proctor because that just seems like disaster fuel. That seems implausible to me. So, and also, incidentally, how is he getting this information? And he won't, of course, say how he's telling this information because, confidential sources and stuff. So, yeah, I have serious doubts on all that, but that's what Turtle Boy apparently is reporting on Twitter. So, noted for whatever value it has. Oh, apparently also we have a new pope. That's exciting. You can take your bets in chat as to who it is. Do you think it's the cardinal from what is it, the Philippines, that does the weekly podcast thing? Is it that guy? Or who are we thinking for Pope? We'll see who we get on Pope. Maybe it's Proctor. Maybe Proctor's the new Pope. I mean, he has a job. He needs a new job. So, could be Proctor.
I ask you to take a look at that document, and if you turn the page, does it begin to, one more page, please. Does it begin to reflect the email chain?
Yes, it does.
Do you remember this email chain?
I remember seeing it when I reviewed it. I don't remember the intricate details of these messages.
Do you remember that photograph?
I don't.
Okay, could you turn the page? Is there text?
Yes, there is.
Okay. Without citing the phone numbers, I'd like you to cite the author of the text, and I'd like you to read the text to the jury.
Do you want me to date it in time or no?
Sure.
August 17th, 2022, 9:44 p.m., 25 seconds. Funny, I am going through his retarded client's phone.
I'd like you to read all of them, please.
Next one, no nudes so far. I hate that man. I truly hate him.
Hey, can you give the author for each comment? And can you start again, because I want us to understand.
I'm sorry, can you repeat that?
The author, whoever makes the comment, I'd like to have the name of the author.
I'm sorry, this document does not identify who the author is, sir.
But do you know? Do you know who the author is?
It identifies this as your phone,
That is, yes.
but each comment doesn't identify who sent it.
No, it does not. I assume it's an extraction from one device, but
I see. If you've made any of the comments yourself, would you tell us?
if I made those comments?
No, if you make any of them in here as you read them, will you point out if you?
Absolutely, absolutely, yes.
Please. Okay. And if you don't know who made the comment, could you just identify that for us as you read it so we know?
Okay, do you want me to continue the next page?
Why don't we start over, because I
Okay.
should have been more clear in my direction. Could you begin again?
So in the beginning, it says, funny, I am going through his retarded client's phone.
Is that your comment?
No, it is not.
Okay, next.
It appears to be the same person because of the way that the extraction happens, and it says no nudes so far. Again, this, I believe it's the same person because all of these are identified as sent. It says, I hate that man. I truly hate him.
Do you have any belief that's Michael Proctor who was writing these?
Yes, I believe
Okay.
that is.
Next, please.
You know it's Proctor. You're
There's
well
a,
aware it's Proctor.
Blank page, and that's the end.
There's been investigation hearings. You're well aware it's Proctor. We all know it's Proctor.
Did you say you were suspended 5 days or lost 5 days vacation?
Lost 5 days of vacation.
Okay. And have you continued on your cases?
Yes, I have.
I want to go back to the evidence that you reviewed in this case.
Okay.
Did you get to look at the ring video for John O'Keefe's home at Meadows?
Yes, I did.
Did you review the video over a period of time of January 28th and January 29th?
I did.
What were you looking for?
We were looking for activity to get a timeline. During investigations, different sources provide you information that can develop into leads. It also helps verify witness statements. It helps verify information that's coming in. We always trust, but we always verify the information that we take in from individuals we do not know. So although it could be a cooperating witness, you still have to verify that their information is accurate. Not that they might be intentionally misleading you, but 3 people can watch the same event and observe it differently. So it's good to talk to individuals and pick up on different facts that they remember, giving you a whole picture of what took place.
Did you review ring video for January 28, 2022 and January 29, 2022?
I did.
With the court's permission, I'd like to show a number of segments of the video from January 28, 2022.
Okay, the one that's already in evidence?
It is, it's Exhibit 6.
Okay.
Thank you. When you reviewed the video from the ring that Ring provided for Mr. O'Keefe's home on Meadows for January 28, 2022. Did you review it from the morning time at about 7:18:55 throughout the evening?
On the 28th?
Yes.
Yes.
Okay. If I could have video 119. Thank you. After that video, did you have an opportunity to look at video at about 5:05 p.m.?
I'm sorry, there was a noise coming from a bag over here. I apologize.
Not a problem.
Can you repeat that question?
Sure. On January 28, 2022, did you have a chance to look at video from the ring at about 5:05 p.m.?
Yes.
Could I have video 145, please? Thank you, Ms. Gilman. Did you have, there's more video. Did you have a chance to look at video from a little later that evening, 7:36 p.m.?
Yes, I did.
Could we have video 149, please? Thank you. In your investigation, did you learn that the defendant's phone connected to Mr. O'Keefe's Wi-Fi at his house on January 29, 2022 at 12:36:39?
Yes.
Did you look for any ring video for that time, 12:36:39?
Yes.
Was there any Ring video on the production that was sent to you by Ring for the time period of around 12:36:39 on the evening of January 29, 2022?
There was no Ring video for that time frame.
Did you look for Ring video around 5:07:58 that morning on January 29, 2022?
Yes, I did.
Could we see video 153, please?
Yeah, I mean that taillight looks mostly intact at that point. So the defense's theory that this is when the taillight completely shattered. I'm not necessarily sure I'm buying that from that image. It's not necessarily easy to tell though. The video quality is poor, but the tail light does look pretty intact comparatively. Let me just go frame by frame here for a second. Because this is like a big issue for the defense. Like this is their theory about when the tail light was broken, right? Yeah, I mean that looks, as much as you can tell, which the conditions are horrible. It's kind of hard to tell either way, to be honest. And it's actually now that I look at it frame by frame, it's kind of hard to tell if that's a different color or if it's the same color. Yeah, that image quality is just hard to tell for sure. I don't know. Maybe it makes more sense if you play it in full speed. Yeah, it's kind of hard to tell, to be honest. No, that looks pretty intact. I don't know.
Thank you. Did you
The
review
LED
that
is red?
video
No,
from
it's not.
50758?
The LED is white.
Yes.
Did you later review video of 54629?
Yes.
Could we play number 154, please?
The LED under the plastic is also red. No, it's not. It's white.
Could you stop that, please? Do you recognize what's in that video?
Also,
Yes, I
why
do.
isn't the bot
What is that?
like getting rid of
That
all caps
is
anymore?
top left corner is Mr. John O'Keefe's vehicle. Middle left side of the screen is a black Lexus SUV registered to Karen Reed with the license plate based on that registration. And then on the right side, I believe that's Miss Carrie Roberts' vehicle.
Did you see the people enter the house?
Yes.
Did you look for further video after the people arrived at 54629?
Yes.
Was there any video of those three people leaving?
No, there was not.
Was there later video at 7:05:16 a.m.?
There was, yes.
Ms. Gilman, can we see video 155, please?
All right. Let's see if I can get the bot to do my spam protection again, since it somehow broke it.
Thank you. Did you later see video at 8:23 a.m.?
Yes.
Could we have exhibit or video 159, please?
Is the bot? Yeah, the bot is here.
Thank you. Did you later see video at 10:36:28?
Yes, I did.
Could we have video 161, please? Could you stop that, please? Do you know who's in that video?
I believe it's Mr. Paul O'Keefe and Mrs. O'Keefe.
Could you please play? Okay, thank you. Did you later look at video of 12:04?
Yes.
And could we please play the 1-minute segment of video 165?
Let me get Nightbot to do it. Is Nightbot even here?
Could you stop that video? Do you know who that is?
I believe that's the defendant.
Continue, please.
See if we get Nightbot to do my caps management for me instead of Stream Elements, because Stream Elements is doing something
Could you
weird.
Stop that. Do you know who exited the car?
I believe that's Mr. Reed.
Okay, continue, please. Thank you. Did you continue to watch the video from the driveway
Yes.
during that time period?
Yes.
Did you see anybody else get out of that car that was in the back?
Yes.
And who did you believe you saw getting out of that car?
I believe it was the defendant's brother and possibly his companion. I don't know who that is.
Did you have a chance to watch the video?
Yes, I did.
At 12:35 p.m., could you play video 174, please?
Give that a shot, see if that helps.
Thank you. Did you look at video from 12:40?
Yes, I did.
Could we have video 171? And 175. Thank you. Did you look for further video to see if there was any video for the time around when the Lexus was taken from Meadows that morning?
Yes.
Was there any video that was produced that shows the time around before and the time that Lexus was removed from that driveway that morning?
There was no. video, no.
When you were at the Sallyport, did you get an opportunity to look at the Lexus's rear taillight area?
Yes, I did.
Did you get to make observations about the damage that you viewed that morning?
Yes, I was.
Did you later have a chance to see, after the snow melted, what that damage looked like?
Yes, I did.
Could I have Exhibit 54, please? Do you recognize what's in that photo?
Yes, I do.
And what do you recognize it to be?
That is the defendant's Lexus SUV that was seized and later processed. It's currently in the Canton Sallyport, I believe.
Could we close up on the right rear taillight, please? Do you notice anything about that right rear taillight?
Yes.
What do you notice?
It's missing a large red portion of the lens.
Is that consistent or inconsistent with the damage that you saw when you first saw that car?
That is 100% consistent.
Did you get an opportunity to see any video or photographs of that right rear taillight before the car was placed in the Sallyport video?
Yes.
Did you view the ring video from Mr. O'Keefe's Meadows Ave address?
Yes.
If we could go back to video 153 from Exhibit 6. If you could play this, please. Did you have a chance to review this video?
Yes.
Is this at 5:07:58 a.m. on January 29, 2000?
Yes, it is.
Could you stop, please? Do you notice anything about the right rear taillight in that video?
Yes.
What do you
Oh,
notice?
It's showing white and is missing the red taillight cover lens.
Could you zoom back out for a second, please? Could you continue? And I'm going to ask you to stop in a second. Stop, please. And do you notice anything about that, still of that video?
Yes, it's consistent with its appearance of missing that red taillight lens.
If you could play the vehicle leaving the driveway, please. Thank you. May I approach, Your Honor?
Yes.
Hand you a document, sir. Do you recognize what's in that?
Yes, I do.
What is it?
It's a still frame from the ring footage taken of the video we just watched of the Lexus SUV leaving, and the large red portion of the rear taillight is missing.
I'd like to move this into evidence.
Okay. Any objections to Jackson?
No, Your Honor.
If I may correct the record, the ring video exhibits are from 12A, not Exhibit 6.
Okay.
At some point later that afternoon, you shared, or mid-afternoon, you went to Dighton, but before that, did you review any other evidence of the damage to that taillight before you and Mr. Proctor even got to the Dighton address?
Yes.
Could I have Exhibit 10, please? Did you have a chance to view still photos from the wellness check that was conducted by the Canton Police Department and videos on the dash cam.
Yes, I did.
Did you review this photograph?
Yes, I did.
And could we show a close-up on Exhibit 11? Did you have a chance to view the dash cam from this footage at 8:26:31 a.m. relative to the damage to that right rear taillight?
Yes, I did.
You shared with us that, you can take that down, please. You shared with us that after this time, somewhere around 3:15, you went to Dighton,
Yes.
and you shared your observations when you got out of your truck and walked towards the car.
Yes.
Was there any difference between the damages that you've seen in the video, the photograph, and what you saw that morning?
The only difference is the amount of snow that's impacted on the vehicle. The damage is consistent. The large red lens is missing in every single piece of, every single image that I saw.
You mentioned that there was a tow of that car in Dighton that you were there for.
Yes.
Were you aware that video footage was provided to us from that tow?
I was made aware, yes.
I'd like to enter into evidence a video from alarm.com.
Okay,
No objection, Honor.
thank you.
Exhibit 105.
Thank you. Did you view the video that was provided to us relative to the right rear taillight?
From alarm.com?
Yes.
Yes.
Court's permission, I'd like to play that for the jury.
Okay.
May I have a moment, Your Honor?
Yes.
This is video 1, Your Honor.
Okay.
Lex is definitely getting their free share of advertising in this trial, man. Lex is getting a lot of product placement out of this thing.
Could you play video 2, please?
I remember this footage from earlier. This is interesting too on the taillight. Let's take a closer look at this one too. You can barely see the taillight in this, so you have to really kind of pay attention. It's not very good. Yeah, I mean, you're definitely seeing that. Definitely looks white to me. Yeah, that looks white.
Could you play video 2, please?
So this is on the 29th. This is at 4 p.m. The car is being towed to the police station, right? So what is the condition of this taillight as it's being towed to the police station? Car is being driven, okay, backwards. And then the car is being driven forwards. The car is in forward gear. It's being driven forwards, and the brake light. Yeah. And that's white. Yeah, that's not red, I don't think. I mean, yeah, I don't think that's red. That seems like a pretty big piece is missing at 4 p.m. Okay. Okay, that's reverse. Yeah. So then
Could
the
you stop, please?
the reverse light's going.
Do you
The
notice
backup
anything
light is
about the
white.
color of-
Yeah, but those aren't the backup lights. That's the brake light. The breakup lights go on when they go in reverse at a different time. You can see it in. Let me show you if I can get it up to play.
Anything about the color?
Show you.
Could you stop, please? Do you notice?
No, I have to go back. The brake light should absolutely be red. It's required to be red. Yeah, the car's in forward gear. It's in forward gear. It's in forward gear. And yep, that's white. It shouldn't be because, of course, in forward gear, it should be red because it's the brake light going on. Car's going forward. And then see, now it's in reverse gear. And see how those white lights at the bottom pop up? That's when it's in reverse. Those white lights at the bottom. So yeah, the taillight pieces, there's a pretty big piece of taillight missing there at 4 o'clock in the afternoon. It seems to me.
Could you stop, please?
The bottom corner is white. It can't possibly be white. That would be illegal. That's not, well, I mean, unless the lens is missing, which is the whole point. Yeah. So the fact that it's white means the lens cap is missing, which is the entire point.
Do you notice anything about the color of the right rear tail light?
Yes, it was white.
Could you continue, please? Thank you. You can put the lights on, please.
So she did it? I'm not saying she did it. I'm just saying the condition of the taillight at 4 p.m. when they're towing it. That's the only claim I'm trying to make. That there's a substantial piece of the taillight missing at 4 p.m. when they're loading it onto the tow truck. That's the only claim I'm trying to make. Because that's what the video depicts. What else is true, I don't know, but that's what that video depicts.
Sir, did you have an opportunity to review video from C.F. McCarthy's on the evening of January 28th, 2022?
Yes, I did.
Did you have an opportunity to review videos from the Waterfall Bar on January?
The bottom right corner is clear on cars. That is not possible, Miss Mandy. That is just simply not possible. Those brake lights have to be red. It is simply not possible that that bottom corner is illuminated if the car is being broken, if the brakes are being applied. That would be illegal. It is not possible. There shouldn't be any illumination other than red if the brake lights are being put on. That's not possible.
January 28th, 2002.
Yes, I did.
Did I say
Bulbs can be red. They can be red, but they often are not. Very, very few manufacturers use red color bulbs. It's not illegal to have a red color bulb, but it's very unusual. And these bulbs are white.
January 20th, January 29th?
There's a clear area for the blinker. Well, first of all, the blinker wouldn't be clear. It would either be amber or red. And the only time there's white is for reverse lights. Reverse lights have to be white. Brake lights have to be red. Turn lights can be red or yellow. So, no, it's not that. Yeah. It's very illegal to have red or blue bulbs. No, it's not. It is not illegal to have a red bulb for a brake light. That is not illegal. It is legal to have a red for the light itself to be red. That is legal under U.S. rules. If it's a brake light, that's legal. It's uncommon, but it's legal.
2020.
Where did the white plastic come from? Well, I mean, it wouldn't be illuminated though, because it couldn't be illuminated. Your claim is that that corner is white plastic and it's illuminated, right? Your claim is that the light shining in that is shining because the light is white. It can't be because because the brake lights are on and the car is in forward. It can't be that it's white that's being illuminated. That would be illegal. It would have to be red. Do you guys not know how this works? Yeah. Amber bulb with clear plastic, that would be possible. Sure. Yeah, that would be legal. It only has to be red. It only has to be white. So it could be clear plastic with an amber bulb. That's true. But that would only be true if the turn signal was on. And the turn signal wasn't on in that shot, so it can't be the turn signal. And also it would be flashing if it were the turn signal, and it wasn't. So it's not that. Yeah.
22.
Yes.
Did you review all the entire relevant time periods?
Yes, I did.
When you reviewed those videos, were there a number of different things you were looking for?
Yes, there was.
Can you share with the jury what you were looking for?
We were looking for...
It's clear plastic with an amber bulb? Well, it could be, but it wouldn't be illuminated. It can't be that in that picture. So I will accept your representation that it's clear plastic with an amber bulb. I'll accept your representation. But that can't be what's being depicted in that image, because the only way that that would be on is if the turn signal was on. And that was the brake light coming on because it went on at the exact same time as the brake light. Right? Because the brake light illuminated at the exact same time. It's the brake light, not the turn signal. That's not what's depicted in that image. So no, that's not what I see in that image. So yeah, no. So I don't see it.
Our consistency in statements that were already received through interviews. We were looking for description of clothing individuals were wearing at the bars, at those locations. We were looking for any evidence of aggressive behavior, any sort of information we could learn to help us with the investigation. We're also looking to see and document how much alcohol consumption was on the recordings.
When you went through the videos, did you happen to have an opportunity to copy and clip portions of relevant time frames regarding alcohol ingestion?
Yes.
Did you put all of those videos together in a sequence to show the course of the night, times when you could identify alcohol ingestion?
Yes, I did.
Did you put that into a video format for a presentation?
Yes, we did.
I think this presentation may take a few minutes.
All right, we'll raise the council sidebar for just a second, please. Jurors, feel free to stand up.
We'll take a break at this point to look at some photos and images that you guys were sending around, because we can sort of spend a little bit of time on this point relating to this. So let's open up some other links while there's a break here and see what value it can offer to the picture relating to what's going on here. All right, so this is a video that was produced by somebody called BN Trouble 31 relating to this taillight. So we'll see what value it has to offer to the picture and if it can offer any further illumination, pun intended, relating to this issue. Let's take a look at this video and see what it shows. Taillight example 2021 Lexus LX 570 OEM taillight. Okay.
I don't think I'm gonna be able to smash it out.
I'm not sure what we're seeing exactly at this point, but okay.
That's with the hammer.
Yeah, I mean, it's really not designed to shatter into 47 pieces. I agree with
How
that.
thick this thing is.
Yeah, shattering into 47 pieces is a lot. It's really
These
not designed
taillights
to
are
do that.
extremely thick.
Yeah, they're pretty thick, yeah. Lexus makes a good product. Did I see the clear corner? I did see the clear portion of it, yes.
This one was already busted. That's why it was easy to shatter with the hammer. This is a genuine
Genuine.
Lexus LX 570 from a 2021.
Okay.
If you just pull it off, that's how you get the big piece. Just see what color it lights up as.
All right. So we're going to see the colors of the bulbs. That's cool.
All the red is gone.
Yeah, it should be. That's pretty typical. Yeah. So you're using basically like a whitish bulb, and the color temperature of this bulb is what is that? They say warmer. It's a warmer white. So yeah, that's fairly typical.
There's no red on this taillight anymore. Even the side marker light is so.
It looks pretty red in this image. I'm not going to lie. So if he's trying to prove it's not red, he's not doing a really good job right now. If you ask me what color that is, I'm like, it looks pretty red to me, but okay.
So bright that it looks white.
Yeah, I'll take your word
You
for
can
it.
clearly see it's red. All the lights are red.
Okay, yeah, so they use LEDs, and the LEDs themselves depict red. That makes sense. Okay, I buy that. But then why are you seeing so much white then if the LEDs are red? It's weird.
That's the brake light. They're just so bright red. They're clearly red. Let's see what happens when smash the diffuser. I don't
Okay.
want to take a chance on short.
I'm not sure what we're trying to prove at this point, but we're having fun doing it. Smashy smash. All right, so that's the clear part. Is the diffuser is clear. So there's like two layers of plastic. There's a clear layer of plastic and also a red layer of plastic. Okay, that sort of makes sense, I guess. All right, fair enough.
I can't even break this chrome piece off there. That is so strong. That thing is thick. I can't even break it.
Yeah.
There's no possible way an arm did that.
No, I have a lot of doubts as to that
Especially
too.
breaking that chrome centerpiece.
I have no problem on the issue that hitting the arm did not cause it to break into 47 pieces. That sounds like some bullshit. Yeah. So if he's trying to prove to me, it's like, yeah, exactly. What are we trying to prove? Is like, what is the question? Right? What exactly is the question? If the question is, did hitting his arm cause it to break into 47 pieces? He says no, and I'm like, yeah, that sounds like some bullshit to me too. It is not designed to do that. It's not supposed to do that. There's no way that happened. I agree with that. Yeah, that's fine.
All right. Now with the diffuser off there, look at the taillight. That's all broken out right there. That's broken. When I move the diffuser, watch the light move. Now the light's gone because there is no bulbs back there. The only thing that makes the lights go down the tail light are these plastic pieces that have the bubble.
Okay.
Without that, the
where's
light
the
does
light?
not go down the tail light.
All right, so there's like a little bulb up in the corner, and then the diffuser diffuses it, and then it turns into red from there. So the clear pieces with the little texture on it is the diffuser flare. Okay, that makes sense. I would think it would be easier just to use like a panel of LEDs, but I don't design cars, so notes for Lexus in the future. Just use a panel of LEDs; it'll be easier, and you can make the LED any color you want, so that's fine too.
Now watch, I'll snake this diffuser back in there and the light will follow it down to where the end of it's broken off. Look, either if that light was broken in John's driveway, there would be no light going down the tail light whatsoever, and it sure would not be white.
Okay.
The red is almost a translucent red.
Yeah.
Now watch, I'll take the diffuser part
It's
out
got to
of
be.
it, the
It's
light
got to be kind of
disappears.
translucent. The light has to get through it. Yeah. It has to be. It has to be
Because
a little
all the
translucent.
light is up at the top, and it shines down on that clear piece,
Yeah.
and the bubbles makes it reflect.
Okay. Well, that was all right.
This is what the tail light would have looked like with the plastic pieces that they showed on in the trial.
Interesting. So his premise that he's going with is if the tail light was as shattered as the state says, then we would have only seen these pieces of light, and we obviously see a lot more light than that. So the tail light is therefore not as shattered as the state is representing. Yeah. Okay. That I buy that premise. I'm sold on that. That's fine.
That would have been missing from the tail light.
Yep.
There would have only been two small lights coming from the top.
Okay, I buy that. I'm sold. Yeah. So therefore, in this image, we can see a lot of light, which suggests at a bare minimum the diffusers are in place. So, yeah, whatever color that is, what we can say is that the diffusers must be there because we're getting the light spread out, regardless of what color it is. So, there, yeah, that's fair. I buy that.
But it looks cleaner.
Forward, please. Thank you.
Red.
And one more. You can see the white light shine. Stop. You can see it clearly missing. You can't plant.
Yeah, again, regardless of what color that is, the light is taking up the entire portion of it. It is spread throughout the space. So suggesting that the diffusing layer is still there. And they found the diffusing layer at the crime scene, so that seems really, really odd. So yeah, that seems counterindicated. How can it be how can the diffusing layer be there and also at the crime scene at the same time? That seems very odd. How can it be in two places at once?
Something that's already gone. And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it's
I see that there's white shining through.
It's still kind of hard to tell what color that is, to be honest. I think it's fair to say that something is wrong with that. Something is distorted, but it's a little hard to tell in this shot. The camera quality isn't as good. It's snowy and distorted. If you told me it was red, I'd believe you. If you told me it was white, I'd believe you. I can say it's different. Something is odd. That's about as close as I can get from that image. Yeah.
Fence position.
It's my memory.
This is what the tail light would have looked.
Yeah, and if the diffusing layer is completely gone, it should look more like that, and it doesn't. So suggesting the diffusing layer is more intact than the state would represent. So yeah, I buy that. I buy a lot of that with his explanation. So fair enough. I'm not sure it necessarily proved what you guys were saying it would prove, but it proved something. It proves the state's theory of the case doesn't quite make sense, but we already knew that anyway, so that's fine. Yeah. That was entertaining.
Yes, I do.
And what is it?
It is the PowerPoint presentation of the timeline from CF McCabe.
I mean, in terms of reasonable doubt, in terms of reasonable doubt, like just look for the simplest thing. And I suppose we can disagree about what the simplest thing is. Like, what is the easiest way to resolve this in favor of the defense, right? Because the state has to prove each and every element. So all you have to do is find one thing, right? Because that's the nature of their burden of proof, right? So it's like we can make our lives simpler. You and I collectively, we can make our lives simpler, and this helps in like clarifying the question, right? So we can make our lives simpler. The state has to prove each and every element beyond a reasonable doubt. If they fail in even one element, they're done, right? That's the nature of it. They have to prove each and every element beyond a reasonable doubt. It's like, okay, great. So like all we have to do is find. So then like, okay, so we want to resolve this in favor of Karen Reed. All right. So what is the easiest way to do that? What is the easiest way to resolve it in favor of Karen Reed? And for my money, the easiest way to resolve it, and maybe different minds will differ, but for me, the easiest way to resolve this in favor of Karen Reed is there's just no fucking way on the face of this earth that a 7,000-pound car going 20 to 25 miles an hour in reverse hit John O'Keefe with enough force to cause him to fly through the air and disable him while simultaneously not having enough force to cause even bruising. So for me, the easiest way to resolve this is in the actus reus. The collision never happened. That's the easiest way to resolve the case. So like, just making my life simple. It's like how did this 7,000-pound car hit him at 25 miles an hour with enough force to cause him to go through the air and disable him, and also simultaneously not cause bruising? How does that happen? I'm not buying it. So therefore I don't have to ask any other questions because I'm done. And I've simplified my life. I have simplified my life by finding the easiest way to resolve it. Oh, Lord. Let's press on.
McCarthy's and Waterfall from January 28th, 2022.
I move this into evidence as an exhibit.
Mr. Jackson is no.
I mean, like, I'll like spot you everything. It's like, because again, like I could just make my life easier, right? It's like, just make my life easier as possible so that we can just like keep my life. I'll spot you that she wanted to kill him. I'll spot you that she was there at the time of the murder and driving backwards at 25 miles an hour. I'll spot you that all the taillight pieces were there at the field the entire time and just later discovered by the snow. I'll spot you that the police are completely great and wonderful and not corrupt in every way. I can spot you everything. Please explain to me how the 7,000-pound car hit him with enough force to disable him and cause him to fly through the air, but not so much as to cause even bruising. Can you please explain that to me? Now, if you explain that to me, then we'll move on to other issues, right? We'll move on to one issue. We'll move on to other issues. If you can say, this is how it makes sense, I'll be like, oh, okay. All right, great. You've explained that to me. Then we'll move on to other exciting things. But let's start with the easiest problem. And once you do that, then we'll move on to other exciting topics. That'd be good. Lol.
Objection?
There's no objection on that.
Exhibit 106.
How's possible? How's possible? The answer is you don't bruise when you're killed instantly. You killed instantly? All right, so assuming that's true, I'll spot you that for the moment. So you think he was killed instantly the moment the car hit him? Or instantly enough? So therefore no bruising. Okay. But still no torn ligaments or broken bones though. So the bruising didn't happen because he was already dead. Sure. Bones break regardless of whether you're dead or not, right? Yeah, I'm pretty sure they do. Ligaments tear regardless of whether you're dead or not, right? Pretty sure they do. So I'll spot you bruising. How come no torn ligaments or broken bones? How's that work? How's that make sense?
Sir, I'm handing you 4 photographs. Do you recognize what they are?
Yeah. Well,
Yes, I do.
What are they?
There's still frames from C.F. McCarthy's on January 28, 2022 at 9:26:01 as timestamped on the footage cam.
Are there 4 photographs?
There are.
Now I move these 4 photographs into
he went into rigor instantly. That protected the bones and ligament.
Want to exhibit again with the letters, please?
Wow, it must have been really cold. It must have been incredibly cold. That's it. His body temperature dropped to 0 before he hit the ground. It was so cold outside. Okay, sure. Let's go with that. Wow. All right. I don't know about that one either, man.
7A through 117.
Sir, I'm showing you 4 more photographs.
Is it Antarctica? I don't know, man. New England's cold. I'm not sure it's that cold. Holy shit.
Yes, I do.
And what are they?
There's still shot photos of the waterfall surveillance footage from the night of 28th into the morning of 29th.
All right, move these 4 photographs into evidence.
No objection, Your Honor.
Yeah, Q squared says you literally cannot die fast enough. The blunt force trauma that caused death doesn't lead to broken capillaries that cause hematoma. Yeah, that seems pretty implausible, Q squared. I'm not a medical expert, but that seems pretty implausible. Even if his heart stopped beating instantly, there's still like blood there, right? I mean, the blood is still like there. And so probably still with a hematoma, I would think, Yeah, that seems difficult to believe.
108A through 108.
Thank you. Your Honor, could I proceed with the PowerPoint presentation?
Yes.
Trooper, I may stop you at a couple points.
Yes, sir.
Could you explain to us what this is?
Yes, from left to right, it is chronological events that took place at C.F. McCarthy's. This is surveillance video from one of their cameras within the bar. It should be noted that the video is time-stamped 12 minutes behind actual time. So when it says 9:03, when it is 9:03,
Excuse me.
the frame will be timestamped 2051, which is 8:51. So that's the time discrepancy, which is consistent throughout the surveillance footage.
So the times that are displayed in those arrows, is that the accurate time?
The arrows are the accurate time, and the time stamped 12 minutes behind actual time.
In these videos, are you identifying drinks that were received and had been consumed by the defendant?
Yes, so
I'm
the
gonna
first
buy you
video
a
as
drink.
it is labeled, it's
Then I'm
the
gonna take you
defendant
home with me.
arriving.
What you gonna do about
The
that?
next one will be
We be like,
the
ooh,
ordering
ooh,
of
oh,
the drink
ooh,
and receiving
ooh,
the actual cocktail.
Okay, let's start with the first
My
video.
Ferrari
903,
changes
please.
gears, your legs hit the chandeliers. We be like, ooh, ooh, oh, ooh, ooh, oh. I'm gonna buy you a drink. I got money in the bank. What you think about that?
You stop it there. Do you recognize who's in that video?
Yes.
From left to right of people that you recognize and identify the clothing they might be wearing?
From left to right, it'll be Mr. John O'Keefe wearing the gray sweatshirt that was displayed earlier. And then the defendant, who he is trying to embrace with one arm there. I do not know who the other individuals are in the shot.
Okay, thank you. If you could continue, please.
I'm not getting any love from chat for my T-Pain impression. I'm sad. You guys are no fun.
If we could proceed to 910. What did that show, sir?
It showed the defendant receiving her first tall vase, cylindrical style cocktail glass with a lime in it and a straw to go along with it.
927, please.
These fans are not spinning. Why are these fans not spinning? Black fans don't spin, only white fans spin? What's this bullshit about? Black fans can spin too. But no spinny. No spinny. Lame. Worst bar ever. No spinny. At least put it on a low speed, get yourself some circulation going, you know what I mean? Not in the winter in New England? Yeah, in the winter in New England. You do realize that fans have two directions, one for the winter and one for the summer, right? So that you can, you do know that, right? Right? Okay, just, yeah. American Pope? No way.
And what was depicted in that video?
The Pope's American?
In that video,
No
we
way.
see the defendant get handed her second cylindrical tall style cocktail glass while she finished the first one and then picked up the second one.
When you've made a relevant observation in the video, please interject and stop so you can point out for us what you've seen.
Absolutely, sir.
Okay. Next, please, 932.
Just Me for 999 says, okay, since we have driverless 18-wheelers in Texas now, if one backs into you and kills you, who gets the murder rap? We have them on Dow to Houston now and Dow to San Antonio later this year. Yeah, interesting legal liability questions for the future. Thank you for your super chat. We have an American Pope, Robert Francis Prevost. Who the hell is this guy? Robert Francis. Didn't we already have a Pope named that? Are we just electing popes named Robert Francis? How old is this guy? He's born. How old is this guy? He's 69 years old? Oh, he's a youngin'. Okay. Born in Chicago. He served in Peru. Pope Francis appointed him as prevost. And apparently he has chosen the name Leo the 14th as Pope. Okay. All right. Well, that's interesting. Okay, we got a Chicagoan. We got a Chicagoan as the Pope. Okay. All right. Well, noted. That's different.
Here the defendant is handed a shot.
Stop, please. Okay.
Right there.
I think we'll just have to play it, and you'll have to speak as you're watching it. It doesn't look like it can be stopped. Sorry, Ms. Gilman.
She's handed a shot by the bartender on the left side of the screen. She picks it up and puts it into her second cocktail glass, making it a third beverage of alcohol content that she's consuming.
He's Peruvian? No, he's born in Chicago. He's an American. Unless he surrendered his U.S. citizenship at some point. USA, USA, USA. I hope he still pays taxes. He has to pay those U.S. taxes on that papal income now. That's a great one for your IRS form. Job occupation, Pope. How much does Pope get paid? That's a good question. What is the salary of Pope? No salary? Lame. You have to do it for free? That sucks. No salary for Pope? He gets a good benefit package. Yeah, well. A Chicagoan Pope. Oof. The city of Chicago is going to be pretty fucking thrilled. They got a pretty heavy Catholic presence there. That should go over pretty well with Chicago, I would think. Man. Okay. That was short too, man. What was that, like only the third vote too to elect him? That was a quick vote. Man. They're speedy. Who knew? I guess he gets a new passport now. That's exciting. Fourth ballot. Oh, okay. It was fourth, not third. I stand corrected. He earned a Bachelor of Science in Math from Villanova University in 1977. He's a mathematician. Okay. He then got a Master's of Divinity degree from Catholic Theological Union in Chicago. He then got a something licentiate of canon law and doctorate of canon law in 1987 from the Pontifical College of St. Thomas Aquinas in Rome. Joined the Argentina mission in 1985. 87, worked as a pastor and director for missions for the Augustine province of Chicago. Then returned to Peru in 88. He was then elected provincial of Augustine province of Chicago, returned to the United States in 99. He then, in 2001, apparently,
So right there we had
served back in Argentina
observed
again.
Mr. O'Keefe retrieve his phone from his rear left jean pocket. And he put it back.
Okay. Maybe he'll create a new papal enclave in Chicago. That'd be cool. It's like Vatican City's cool and all, but maybe he takes up residence in Chicago. That'd be neat. He's Pope. He can do whatever the fuck he wants. That's fine by me. Yeah, he's just going to get himself a little 2-bedroom in Chicago. It'll be fine. Better pizza too. Yeah, he can be an evangelicalist for Chicago pizza.
Now
Deep
the
dish,
defendant picks
deep
up
dish is
her
best
second
dish.
cocktail glass with the added shot in it.
The Eucharist is now
And
the Eucharist
consume-
is now deep dish pizza.
Could we proceed to the next video, please? This is now 9:45 p.m.
Yes, sir.
But not a pepperoni pizza. If it's a pepperoni pizza, then the waitress has to sign and send it back. So, sausage
The
all the way, which is
bartender
more
hands over
Chicagoan,
a-
to be honest. So,
Another cocktail glass
sausage only, not
and some
pepperoni.
beers. The shot goes into the empty one after it's poured into the new cocktail glass. So that's drink number 4.
Does it also depict Mr. O'Keefe putting his cell phone in his back pocket again?
Yes.
By 9:45, how many drinks have been served to the defendant?
4 drinks.
4 drinks between 9:10 and 9:45?
That's correct.
What is
in,
his position on
35
waffles,
minutes,
though?
4 drinks.
That's critical
Could
information.
we proceed to the next screen, please?
He's not from the
10 and 9
South.
p.m.?
So he might not understand the magic of waffles. That's disappointing.
Here, the defendant speaks with the bartender and gestures that she wants a shot.
Objection.
The objection sustained.
Move to strike.
I'll strike that.
Mr. O'Keefe on his cell phone again?
Yes. And he puts it in his back pocket.
Waffle crust pizza. Ooh, promising. Now you're talking.
The defendant is showing Mr. O'Keefe the middle finger, and then puts beverages on the bar.
Fans still not spinning. Fans no spin. Fans should spin. The lack of spinning, it hurts my soul. My soul is hurt. Is Pope Leo available for a quick call? If Pope Leo would like to join the stream, by the way, let me know. He can help me out on these issues. Does anyone have like his Twitter or something? I'll send him a link.
Should I proceed, Your Honor?
Yes.
Can I be the official streamer of the
What
Vatican?
is the
That'd
drink
be
count
good.
at that point?
At that point, it's 4 drinks.
Could we have the next?
You can give me a little streaming room set up right there in the in Vatican City. Be awesome, man.
Mr. O'Keefe brings over a couple of beverages. The defendant retrieves the cocktail glass. A shot glass is picked up by one of the patrons, and the defendant retrieves it from him and places it back on the bar.
I can learn about Vatican law. That'd be interesting on a lot of levels. Oof. A whole new discipline to learn there. Holy man, that'd be a lot. Yeah. Take the Vatican bar exam. Ew. That's a lot. The Holy See, yeah.
The defendant is consuming the beverage in her hand, places it on the bar.
All streams to now be in Latin.
And then
What time are we at now?
That was 10:34, so we're moving to 10:37.
What is the drink count at 10:34?
That is 5 drinks at that point.
Could we play 10:37, please?
I took a little bit of Latin in middle school. I still remember my Roman numerals. I got that going for me.
The bartender makes 4 shots, top left corner. She's seen preparing the 4 shot glasses. 2 are on the bar top now. She retrieves 2 more.
Looks like a nice little venue. You know, simple. It's clean. It's a clean venue. I'll give them that. I'd go have a drink here. But they got to put on the spinny fans.
10:41, please.
Here, the 4 shot glasses are redistributed. Pours it into her drink. She does not consume it from the shot glass.
Your Honor, no objection to the last comment.
Okay, I'll strike that.
I want some nachos now. Do you think they serve nachos?
The next video, please.
Now, as the Mr. O'Keefe and the defendant are getting ready to leave, the defendant is holding the drink in her left hand, continues to sip on it.
Sometimes you want to go where everybody knows your name.
And the 2 walk out of the bar.
And they're
without-
always glad you came.
The beverage in their hand being deposited anyway.
At 10:53, how many drinks have been served to the defendant at this point?
7.
Objection, Your Honor.
I'm going to sustain the objection.
Move to strike.
I'll strike that.
Next slide. And is
So
this,
I'm going to actually see counsel inside who's on this.
And apparently there's now just 20 minutes of bullshit, so that apparently brings us to live. And the court is apparently in recess for 20 minutes. Is that my lunch break? Oh, it is my lunch break. Okay, so I'm going to take 20 minutes to get some lunch. So that's fine. I'm going to take 20 minutes and have lunch, and then I will see you on the next stream. And then I have to figure out what I'm doing for lunch. I don't know if I'm just going to have meatballs again. Probably. I don't know. We'll figure out something. I will see you guys in 20 minutes. Have a good one. And yeah, that's it. Until next time, I've been on Civil Law. Hope you have a great one. Bye-bye for now.